When we left off yesterday, I believe our next witness is Dr. Mashimba.
That's correct, Your Honor. Liberty would call Brian Mashimba.
Good morning, Judge. Commissioner Sylvia is here.
Good morning.
Commissioner Holzman's here.
Please raise your right hand. Solemnly swear from the testimony about to give in this matter is the truth, the whole truth, nothing but the truth.
I swear.
Thank you.
Mr. Mashimba, you can take your mask off, I think, while you're on the witness stand, if that would be helpful.
Thank you.
Would you state your name?
My name is Brian Mashimba.
And by whom are you employed and in what capacity?
Liberty Utilities as a Senior Director in charge of generation operations.
And that includes generation operations for the Empire District Electric Company, which does business as Liberty.
Yes, sir.
Have you caused to be prepared for purposes of this proceeding certain rebuttal testimony in question and answer form?
Yes.
Has it been prepared in both public and confidential formats?
Yes.
Is it your understanding that your rebuttal testimony has been marked as Exhibit 10, both public and confidential for identification?
Yes.
Do you have any changes that you would like to make to that testimony at this time?
No.
If I ask you the questions which are contained in Exhibit 10 today, would your answers be the same?
Yes, sir.
Are those answers true and correct to the best of your information, knowledge, and belief?
Yes, sir.
Your Honor, I would offer Exhibit 10 into evidence in both public and confidential formats and tender the witness for cross-examination.
All right, 10 public and 10 confidential have been offered. Any objections to their receipt? Hearing none, they will be received. For cross-examination, we would begin with Renew Missouri. Their attorney has been excused from appearing today for MECG.
No, thank you, Judge.
For staff.
Thank you, Judge. Kurt Stokes on behalf of staff this morning. Dr. Mashimba, is it true that combustion tuning of a gas turbine is a process of controlling the fuel split ratio and the amount of combustion air to find the optimized combustion condition?
True.
And is it true that combustion tuning must be ensured to avoid various combustion instability factors for the stable operation of a gas turbine?
True.
And is it true that tuning is done routinely at given ambient conditions or as ambient conditions change?
True.
Your Honor, can we go to in camera, closed? I think we're going to be getting into some highly confidential information very briefly.
Okay. We are in camera then. Right, we're out of the in-camera and public counsel.
Dr. Mashemba, you testify that, let's see, because of the temperature, it was very difficult to get number 2 diesel to ignite. You recall that in your testimony?
Yes, sir.
My experience is that with cold engines, that a lot of times you do an additive, something like ether or some other combustible hydrocarbon, to get things going before you move forward with your less volatile fuel. Do River 1011 or 10, either one, have that capability?
According to the material safe data sheet that we have on the number 2 diesel that we use as backup emergency fuel oil, and under the temperatures that the Riverton 10 operates, the range it operates in, the Winter Storm Uri was such a unique event that that happened, and the events that subsequently, unfolded were unforeseen because of how just aggressive and unique that that event was. In our operations manuals, it calls for some type of heating system to be utilized, but the heating system would be fired from available, electricity, which during this system, when everything was shutting down and natural gas was shut down, and everything was really, for lack of better words, falling around us because of how extreme the conditions were. Even those heating system would not have worked. So that's what we found ourselves against.
So just to make sure I understand your testimony, there wasn't any, I guess, procedure for using an alternative fuel to the diesel to get things heated up and running. The procedure you have in place is to heat the equipment so that the diesel then is, I guess, reaches a temperature where it'll ignite. Is that correct?
Yes.
Thank you.
Anything further?
Oh, no.
All right, thank you. Then, any questions from the commissioners online? Okay,
No questions, Judge.
thank you.
No questions, Judge.
I do have some questions. And I don't know that I'm going to get into anything highly confidential, but if I do, somebody stop me and we'll go back in camera. First of all, can you just explain the concept of a black start? Why is that important?
Black start essentially is when you have to restart generation from a blackout. So if there was a total collapse of the system, failure of the system, and there's blackout, all the generating units that are interconnected ordinarily and generate together to supply load to load centers, all that collapses. For that interconnectedness to be reestablished, there's a unit that is designated to do that from an emergency fuel source, such as number 2 diesel fuel that we have at Riverton. So ordinarily, then you'd fire that unit on the emergency fuel oil and allow it to get to a certain generation capacity to allow other units to start coming on and reestablish the interconnectedness.
Okay. And it's my understanding that you can't just start up the coal-fired plant without electricity coming into the system.
That's true.
To power equipment and so forth.
That's true.
Right. There's been testimony about test firing and tuning. Can you explain those two terms and how are they different?
Tuning is essentially something that you do to model the behavior of your engine during certain conditions. You want to get the maximum generation capacity with minimal impact, such as emissions. So it's an iterative process, technical engineering process of looking at oxygen fuel ratio and mixing with ignition for optimal combustion dynamics, and to get your most output at a given ambient temperature with minimal emissions from the combustion process. It's recommended when conditions drastically change and you want to operate in the best range possible.
Okay. Now, tuning is you said it's based on the ambient test temperature.
Yeah.
So if you want to tune your unit to operate at 70 degrees, do you have to be doing the tuning at 70 degrees?
Yes.
So similarly, if you want to tune it for 10 below zero, you'd also have to be testing or tuning it at 10 below zero?
Yes.
Okay. And then what about test firing? What is that?
Well, test firing could be just you wanting to make sure that when you want to ignite your combustion engine, it's going to ignite and run to full speed, no load, or whatever other things that you want to test during that firing.
Okay. So just starting it up without actually generating, well, without sending electricity out into the grid?
Yes.
Okay. Does the permit for Riverton 10 and 11 allow for the units to be test fired with fuel oil?
No.
Okay. And why is that?
The only time we are allowed to operate a black start unit on emergency fuel is one, if there's a total breakdown of the primary energy source. And secondly, the need for electricity from that station can only be met by that black start unit. So essentially, you have to get into a situation like Winter Storm Uri. Otherwise, the permit won't allow you to do anything, to test, to tune, or to run.
And this is based on the Kansas air permits?
Yes, KDHE permit, yes, air permit.
Is that just a Kansas type requirement, or does every state have similar kind of requirements?
I'm not sure.
And how frequently are these Riverton units test fired with fuel oil?
We don't do it. The permit doesn't allow us.
They never do it?
Yeah, the permit doesn't allow us.
Okay. Now, I've got some questions about sections 6A and 6B and 6D and 6E, which I believe are of the from the Riverton 1011 permits. They talk about different conditions in which tests can be made. Can you explain the difference in testing in those sections of the permit?
I think if you're referring to the conditions and which the permit allows us to operate a black start unit, essentially what it says is that one, the primary, energy source that you use, in our case, natural gas, that system has to be not available, just to break down. Then secondly, there will be no other way that generation from Riverton plant can happen unless you use the black start unit. That's the time that now you are able to use that. The permit then allows you to operate, the black start unit. And in our case, during Winter Storm Uri, on February 15th, those conditions were met, and Unit 11, which was black start capable, was then attempted, to run. And we attempted over a period of 28 hours, we attempted 26 starts. We expended all the energy in trying to be able to fire and ignite the unit, including streamlining some of the redundant logic and some procedures that we could, streamline as per the operations manual allowance. And still, the extreme nature of the temperatures that came through, the sub-zero temperatures, were just that difficult.
After Winter Storm Uri was over, were you able to determine what went wrong, why the unit wouldn't start in particular?
Well, preliminary investigations into some of the events that happened point to just the unit was, we were attempting to operate the unit outside its design parameters. It was just extremely cold.
Okay. That's all the questions I have then. Any recross based on the questions from the bench?
Yes, Judge. This is Kurt Stokes for staff again.
Okay.
Dr. Muchimba, you attached the Kansas Air Permit as Schedule BM-2 to your rebuttal testimony, correct?
Correct.
And that is a true and accurate copy of Liberty's Air Permit?
Correct.
At page 14 of 72 of that schedule, it's actually I should say pages 11, page 13 through 14 of 72. Under paragraph 6, it begins the use of number 2 fuel oil in the unit number 10 and unit number 11 is permitted only under the following conditions. Is that accurate?
Go ahead.
Is that accurate?
If that's what it says.
Okay. Do you need a copy? Permission to approach the bench and the
You may.
witness?
I have a copy, but thank you.
So is that correct?
Correct.
And then if you turn to page 14, subparagraph C under that says, the owner or operator, is that referring to Liberty,
Yes.
owner and operator?
Yes.
And then shall be permitted to use distillate fuel oils. Distillate fuel oils is the fuel oils referred to earlier, correct?
Correct.
Shall be permitted to use distillate fuel oils as needed to meet the Black Start testing requirements by any federal or state regulatory agency, correct?
Correct.
And you said that the Black Start rules under NERC are that it be tested every 3 years, correct?
Correct.
And that part at the end, it says none of the electricity produced during the test shall be sold on the bulk electrical system, correct?
Correct.
Okay. Now, you also said earlier that tuning is recommended when conditions drastically change.
Correct.
Did conditions drastically change during Winter Storm Uri?
Yes.
No further questions.
All right. Public counsel.
Nathan Williams. You recall testifying in response to the RLJ that the units were, during Storm Uri, would have been operating outside their operating parameters, and that's why they did not operate?
Correct.
What operating parameters were they outside of?
By that I meant every design of a plant has certain conditions that it assumes. And the sub-zero temperatures that we experienced during Winter Storm Uri were the first of its kind.
Was the issue at the plant getting the fuel into the unit?
The issues where we failed to ignite certainly had to do with the temperature being very cold, sub-zero, very heavy, the emergency fuel oil being very cold, viscosity issues and flow issues, and when we tried to ignite, failure to ignite as a result.
I've heard the term of diesel gelling before. Was that describe what occurred at the plant? Are you familiar with that term?
I'm not familiar.
Well, you mentioned viscosity. Just how viscous did the diesel fuel get?
Yeah.
Sorry, diesel fuel oil get?
Yeah, the number two, fuel oil gets impacted by the temperature, and that was certainly not the ideal operation temperature for it.
No further questions.
Then redirect.
Thank you, Your Honor. I'm going to start, I guess, in the public session, but I'll probably need to go in camera at one point. And I forgot to announce who it was, Dean Cooper on behalf of Liberty. Mr. Mashimba, you talked about what tuning is, correct?
Yes, sir.
Will tuning on natural gas help anything for running the unit on fuel oil, or do you have to tune separately for natural gas and separately for fuel oil?
Yeah, those are two different fuels, different characteristics and parameters, and tuning on natural gas would not translate the same results to fuel oil.
Is tuning something that Liberty does on its own, or does it use a third-party consultant for that?
A third-party consultant comes in because there's quite a bit of tweaking that has to happen. A controls engineer has to be there and walk the oxygen curve, oxygen trim, and iterate at every step, seeing how the engine will perform. You essentially stretching the engine to its limits, and several times you trip, cause several trips along the way as you try to find that optimal environment.
So not something you decide to do you're going to do in the morning and then you conduct it in the afternoon.
No.
I take it this is a long planning process.
It's a long planning process.
Objection leading.
Sustained tech.
How much planning does it entail to tune?
It's sometimes it's as long as a year because normally we would attempt to tune whenever there's a modification, obviously, either in the control scheme or things like that, or the ambient temperatures changes. So summertime, if we're going to see a lot of different temperatures, we may tune for summer, and then we tune for other temperatures. So it's several months of planning.
You were asked a question by the judge about kind of generally about why you're not allowed to tune on fuel oil, and we kind of danced around it a little bit. I think did you refer to the air pollution permit as the basis for why you don't, correct?
That is correct. On emergency fuel oil, there is no provision in our air permit to tune or operate any of the two dual fuel engines at Riverton.
Let's take a step back from that, though. What is the reason that you are prohibited from tuning on fuel oil? Is fuel oil? What was the danger to the environment, I suppose, from the fuel oil?
Yeah. I think the reason has to do with the fact that combusting number two fuel oil in an emergency, the type of fuel it is not something that you just nilly-willy want to use. It's the way it burns, the emissions it puts out, and the harmful emissions that can come from it.
So, not something you decide to do in the morning and then you conduct it in the afternoon. I take it this is a long planning process.
Objection leading.
Objection leading.
It's sometimes it's a long planning process. And the harmful emissions that can come from it.
Judge, could we go in camera at this point?
Back into regular session then.
And that's all the questions I have.
Thank you. Then Dr. Mashimba, you can step down.
Thank you.
Next witness is Drew Londahl.
We would call Drew Landau to the stand.
Okay. Solemnly swear or affirm the testimony you're about to give in this matter is the truth, the whole truth, and nothing but the truth.
I do.
Thank you. You may inquire.
You'll state your full name, please.
Drew Landell,
By whom are you employed and in what capacity?
Liberty Utilities Service Corp., as the Director of Strategic Projects.
And does that include work for the Empire District Electric Company?
It does.
Did you prepare pre-filed testimony that has been marked as Exhibits 13 and 14 in both public and confidential versions?
Yes.
Do you have any changes for that testimony?
I do not.
If I asked you those same questions from your direct testimony and your sur rebuttal testimony today, would your answers be substantially the same?
Yes.
And are those answers true and correct to the best of your information, knowledge, and belief?
Yes.
I move for the admission of Exhibits 13, public and confidential, and 14, public and confidential, and tender the witness for cross-examination.
Exhibits,
Your Honor, I don't have an objection per se, probably just a clarification that there are active hyperlinks in Mr. Landau's documents, particularly pages 3, 4, 6, and 8 of his sur rebuttal. I just want to make sure that whatever documents existed at that link at the time that it was prepared, today, or whatever might exist in the future, are not being offered into the record. Otherwise, I would have an objection. Only to the having those documents included.
to the active hyperlinks.
We were not asking for those complete documents to be admitted into the record. They're simply footnotes for citations.
Okay. That satisfies staff's concerns?
Yes.
With that understanding, 13 and 14, public and confidential, will be received. And for cross-examination, we begin with MECG.
No questions, thank you, Judge.
For staff,
Kurt Stokes for staff, no questions?
public counsel.
Thank you, Judge. Nathan Williams, good morning.
Good morning.
In your testimony, you've attached some schedules of work product of other parties, Black and Beach and Midwest Environmental Consultants. You recall that?
Sur rebuttal or direct? The answer is yes, but either way, actually.
It doesn't matter
Yeah,
where
yeah.
particularly. Did you personally participate in the preparation of any of those decommissioning cost estimates?
Yes.
And how did you participate?
Our team that works in our department strategic projects participated with the actual team members at Asbury and our project managers to help direct Black and Veatch on what we wanted to do, how we wanted to ultimately dispose of the facility, and have them go and do their estimate. They use their extensive background and experience on dismantlement, and they're a very large firm that has a lot of information, so they did the work of the estimate. We told them, we're the ones wanting to, move forward with this project.
So it was the consultants who actually came up with the amount of the estimates.
Yes.
And didn't the Black and Veatch estimate change substantially between when it was first given, it looks like, I believe, January 24th of 2020, and the subsequent estimate in October of 21?
It did.
I know I believe the amounts are highly confidential, so I didn't want to go there.
Correct.
But can you give an order of magnitude of the difference?
Nearly, it was removed, or sorry, the cost was under half from the original to the updated.
Wasn't it about a tenth?
It was, I'd be happy to speak to the numbers themselves, but yes, it was considerable.
Well, it's in your, let me see, your direct schedule DWL-2 on page 5 of the, well, by the pagination of the schedule, it would be page 8 of 9. The actual numbers appear there, do they not, under total cost including salvage?
Yes,
And that's the Black and Veatch decommissioning cost study, correct?
correct.
no further questions of this witness at this time. Thank you.
Thank you. We'll come up for questions from the bench. Any questions from the commissioners on the line?
No commissioners, no questions, Judge, thank you.
Thank you. I have no questions either, so no need for recross. Any redirect?
No questions, thank you.
Okay. Then, Mr. Lindahl, you can step down. I believe we're moving over to a staff witness, Ms. McMillan.
Yes, Judge.
Thank you. Good morning.
Morning.
Please raise your right hand. Do you solemnly swear or affirm the testimony about to give in this matter is the truth, the whole truth, and nothing but the truth?
I do.
Thank you. You may inquire.
Thank you, Your Honor. Kurt Stokes, on behalf of staff here. Ms. McMillan, can you please state your full name for the record?
It's Amanda C. McMillan.
And can you state in what capacity you are employed by the staff of the commission?
I'm a Utility Regulatory Audit Unit Supervisor.
And have you prepared in these proceedings rebuttal testimony marked as Exhibit 100, surrebuttal testimony marked as Exhibit 101, and certain calculations marked Exhibit 112, Exhibit 113?
Correct.
And you have corrections to make to these documents?
Yes, to rebuttal testimony.
And can you state what those corrections are?
Okay, starting on page 3, we had an update to our calculations for carrying costs for Storm Uri, and we have now moved to long-term debt of 4.65%, which causes these changes. The first one is on page 3 of my rebuttal, on line 4. I need to remove the word variable, change short to long, and then delete everything after debt rate, continuing through line 5. The next change would be on page 3, line 17. That number is now $197,428,807. And in table 1, I have 3 changes. One is the accrued carrying cost is now $15,242,121. The upfront financing cost are $3,560,713, and the total is $197,428,807. And then on page 4, starting on line 14, short-term should be long-term. And on 15, in the parentheses, it should be 0.39 instead of 0.30, and 4.65 instead of 3.58. And then my last change would be on page 5, on line 4. It's $3 million, new number is $3,560,713. And those are all the changes I have.
Okay. Now,
Except for
Exhibit 112, you had some corrections to your URI calculations, correct?
Correct.
And can you describe those just very briefly?
It was just the update from what we thought was short-term debt to long-term debt
Okay.
for the carrying costs for Storm Uri.
Okay. And your understanding is that that copy of the updated Exhibit 112 has been shared with the parties?
Correct.
Okay. With the corrections you just stated, if I were to ask you the questions in those documents, would the answers be the same?
Yes.
And are the others same corrected answers true and correct to the best of your knowledge and belief?
Yes.
Okay. Your Honor, I would move Staff Exhibit 100, Staff Exhibit 101, Staff Exhibit 112, and Staff Exhibit 113 into the record.
Excuse me, Your Honor, Dean Cooper for Liberty. Not an objection per se, but as was mentioned, I think on Exhibit 112, we just got that this morning. We don't necessarily have a problem, but if you could defer your ruling on that until we have a chance to look at it a little bit more closely, we would appreciate that.
Okay, I can do that. I also want to ask about 112, as you indicated the updated version has been provided to the parties. Is that, have you updated it to the commission's website as well? I'm just wondering what, what has been offered.
I'll need to look. I think we circulated at least by email this morning.
I don't think it's officially been filed in EFIS.
I have not seen
Well, I'm
EFIS
not-
yet.
Okay, because it was originally filed in EFIS, right?
Yes,
A few days ago.
yeah. So we would need to update that.
Okay, well, we'll defer ruling on that at this point anyway, so. So 100, 101 have been offered, as well as 113. Any objections to those documents being received? Hearing none, they will be received. And as I indicated with 112, it's been offered, and we'll defer ruling on that to give parties time to look at that.
And then I tender the witness for cross.
Okay. And for cross, we begin with MECG.
No questions, Judge.
And then to Liberty.
Yes, Your Honor. Ms. McMillan, in your rebuttal testimony, I think this is on page 8, you talk about the use of long-term debt rate as for carrying costs, correct? And I'm looking at lines 1 through 3 if you want to reference.
And that's in reference to Asbury, correct?
Correct,
Okay.
yes.
Yes, you are correct.
And I take, at the end of that sentence, you talk about carrying rates to be applied from May to December of 2022, correct?
Correct.
And I take it from that you're not applying carrying costs to the Asbury balance starting with the retirement of Asbury through May of 2022. Is that correct?
Not in this calculation. It was included in the Asbury liability, AAO, that's included in the 2019 rate case.
Okay, so that's part of my question then. So what has been done from the date of retirement through May of 2022 is you've just assumed that there's a return built into the rates, correct?
Correct.
However, that return that's built into the rates has been added to the liability, correct? So if that liability is applied, the result of that is that there will be no return and no carrying costs on Asbury from retirement through May of 2022. Is that correct?
Objection compound.
I'll overrule that objection. You can answer the question or have it asked again if you'd like.
Can you please repeat the question?
Sure, and we can break that up. So we're just talking about the fact that in your carrying cost calculation, you don't add any carrying costs from the date of retirement of Asbury through May of 2022, correct?
Correct. In that calculation, that's correct.
Okay. And you did point out that there's it's assumed that there is a return for Asbury that's been built into the rates that would have been in effect from retirement through May of 2022, correct?
Correct.
Okay. But ultimately, that assumed return is included in the Asbury liability, correct?
Correct.
So if we take that liability, we use that liability to offset against the Asbury amounts, the result of that is that there is no return and there are no carrying costs for the company from the date of retirement through May of 2022. Is that correct?
Well, it was included in rates, so they're getting a return on, but we don't believe that the company should get a return on and of the unrecovered piece of Asbury. So there should be some sharing between the customers and the shareholders.
But you would acknowledge, wouldn't you, that under the way you've treated it, there is no return that ultimately goes to the company because it's a part of what's in the rates is a part of the liability, correct?
Correct.
And you haven't done anything to add a carrying cost to that period from the date of retirement through May of 2022, correct?
Correct.
So if the result of that is the company receives, at the end of this process, receives no return and no carrying costs, isn't that contrary to the securitization statute, which would call for carrying costs?
Objection calls for legal conclusion.
I'll overrule that. If you can answer, you can go ahead.
I don't know.
That's all the questions I have here.
For public counsel.
No questions, thank you.
All right. Questions from the commissioners online?
No questions.
Thank you. I do have a couple questions. This is kind of a general question, but on page 5, line 18 through page 6 of your rebuttal testimony, you stated that it was staff's position that the prudent costs incurred by Liberty for the early retirement of Asbury are just and reasonable and in the public interest. Why does staff believe these costs associated with the early retirement were just and reasonable?
They've been proven just and reasonable in the previous cases. And they have to be proved just and reasonable to be securitized.
Okay.
And staff has made no prudency disallowances in the past 2 rate cases.
And the past 2 rate cases are the ones you referred to earlier as where they were proven just and reasonable.
Correct.
Okay.
At least for Asbury.
Okay. This is under issue 3I. It's about the value of Asbury's AAO regulatory liability. Staff stated its position was that the AAO was worth, the value was $75.8 million, and in the statement of position it cited a number in the schedule presented by Mr. Davis. Was the attachment 3 to your response include work papers? Do those work papers support that amount?
The 75.8, yes.
Yes, okay. What items are included in the amount, and why is your number different from the value put forth by OPC and Liberty?
The biggest difference between staff and Liberty would be the AAO liability, the return on the liability that the customers have already been paying back since the AAO went into effect. And with OPC...
And that's what you were just discussing with counsel for Liberty, is that correct?
Correct. And there's also a portion that is related to the ADIT and excess ADIT.
Okay.
And then the difference between staff and OPC, I think the biggest difference is they removed the amount for the AQCS.
Okay, can you just tell me what AQCS is?
It's part of the environmental upgrades that they did in 2014.
Okay, thank you. That's the only questions I have then. Any recross based on those questions from the bench? Hearing none. Redirect.
Kurt Stokes for staff. Ms. McMillan, you were asked about the return on portion of staff's calculated AAO regulatory liability.
Correct.
Can you explain what a return on a regulatory liability encompasses?
It's the return on the money that the customers already put forward when they paid for Asbury and rates in the 2019 case until new rates went into effect in the most recent case.
Now, in the 2019 rate case, ratepayers paid a full return of and on Asbury, correct?
Correct.
And was it staff's position in the 2021 rate case that a return on and of Asbury was just and reasonable?
No, staff's position on Asbury was there was no return on, just return of in the rate case until it was moved to securitization.
So staff's position that the return on should be returned to ratepayers is consistent with its position in the 2021 rate case?
Correct.
And tell me again, just a reminder, when we say return of, what does that mean?
It's basically the return of the expense, so it's going, they're getting 100% recovery of the expense portion a return of, instead of return on, where they get a portion that is the weighted average cost of capital typically.
Okay, so the return on, that's the profit,
Correct,
and then the return of is just the return of what was invested?
correct.
Okay. Now, you say that there were no carrying costs from, under your recommendation, from the date Asbury was retired, correct?
Correct.
So when Asbury retired, was it used and useful?
No, it was not.
Did Asbury serve customers during Winter Storm Uri?
It did not.
And what's Liberty seeking to recover here for Uri and Asbury?
Altogether, around 266 million.
Is it
Or no, I'm sorry, 362 million.
And are there any costs that associated with Uri and Asbury that Liberty is not seeking to recover?
Not that I'm aware of.
So there's no costs incurred with Uri, and there's no expenses associated with Asbury that Liberty is seeking to share with ratepayers.
Not that I'm aware of.
In staff's opinion, is it just and reasonable?
No, it is not.
No further questions.
I need to apologize here. I do have one more question. After I ask the question, we'll go through the whole process again of recross and redirect. But this is a question about staff's proposed net book value for Asbury. What is that proposed net book value?
We agree with the company's number of the 159.4 million.
Okay. And how was that number calculated?
It's actually calculated in Charlotte Emery's rebuttal testimony for the company. It was their updated amount of actual plant that was retired, and then a portion for construction projects that were never finished.
Okay. And staff accepts those numbers?
Yes.
Okay. What was the assumed closure date of Asbury used in those calculations?
There's a difference in opinion. Staff believes the last date that they ran Asbury was December 2019, and therefore that should be date of retirement. The company believes it should be when it removed from SVP, which was March 1st of 2020.
And does that assumed closure date have any effect on the calculation of net book value for Asbury?
It does, a slight difference. Staff's calculation is about $3 million with depreciation and other cost. It's around $3 million.
Did staff's calculation, or staff's calculation shown anywhere in your work papers?
For the difference between us and the company on, no, but I can present those work papers.
Okay. And they're not part of what was already submitted?
I don't believe so.
Okay. Staff, would you be able to offer those work papers at some point? I don't suppose you have them in front of you now.
No, I don't right now, but I could by the end of the day, if not earlier.
This is Nathan Williams for Public Counsel. Judge, are you asking for a reconciliation of the parties' positions?
I don't know, am I?
Sure sounds like a couple of them at least.
Okay. Well, I think we would like to be able to see those calculations. If the parties have additional testimony or anything that they wish to present for that, I certainly don't have any objection to those. I guess I'm not really understanding what you mean by a reconciliation of the positions.
Just what the parties' positions are and how they, I guess you want something about how they arrived at them?
As far as the net book value for Asbury? Is that what you're talking about?
Well, at least that.
Well, I think at some point a reconciliation would certainly be helpful. And you're talking about a reconciliation on all issues?
Depends on what the commission wants, of course.
I think we would need that at some point if there were to be an appeal, certainly. Or at least I assume we would, similar to what would be done in a rate case. Let me think about that a little bit more, and we'll come back to that. At this point, I'm concerned about getting those calculations into the record for staff. If staff can get those as an additional exhibit. Okay,
We can do that.
thank you. All right, any recross based on those questions from the bench, from that last question? Any additional redirect?
Maybe just one, Your Honor, this is Kurt Stokes for staff. Can you turn to page 3 of, I believe it's Exhibit 113. It's the, referred to as Attachment 3 also.
You said page 3
Yes.
of the attachment 3, okay?
And this is the calculation of the Asbury AAO liability. Is the difference that we're talking about between the retirement dates, is that reflected in the depreciation expense on line 14 there, or is that calculation reflected somewhere else?
That amount is what staff's calculation is. I would have to take the difference in what the company included in their liability and then what we included for depreciation for all those items under return on Asbury.
You know what, Your Honor, I think maybe we'll just submit the calculation later. I don't know if I can walk through all of it now without taking up a lot of time.
Okay,
I apologize.
very good then. Then Ms. McMillan, you can step down.
Thank you.
And we're due for a break. Let's come back at 10 o'clock. And I believe the next witness is Kim Boland.
Yes, Your Honor.
Please raise your right hand. You solemnly swear or affirm testimony you're about to give us, given this matter is the truth, the whole truth, and nothing but the truth.
I do.
Thank you. You may inquire.
Good morning, Ms. Boland. Can you state your full name for the record, please?
My name is Kimberly Bolin.
And what is your, in what capacity are you employed with the staff of the commission?
I am the Director of Financial and Business Analysis Division of the staff.
Have you prepared in these proceedings rebuttal testimony marked Exhibit 102, both public and confidential, surrebuttal testimony marked as Exhibit 103, and certain calculations marked as Exhibit 111?
Yes, I have.
Do you have any corrections to those documents?
Yes, I have a correction to my surrebuttal testimony. On page 3, in the table that starts on line 14, the total amount for Liberty should be $33,752,995.
And can you just briefly explain that correction?
It was an error, an adding error in my table.
Okay. And that line just reflects Liberty's position on,
Yes.
on something? Okay.
Yeah.
With that correction, if I were to ask you the questions in these documents, would the answers be the same?
Yes, they would.
And would the corrected answers, are the correct answers true and correct to the best of your knowledge and belief?
Yes, they are.
Your Honor, I offer exhibits 102, both public and confidential, 103, and 111 into the record.
All right, exhibits 102, 103, and 111 have been offered. Any objections to their receipt? Hearing none, they will be received.
And I tender the witness for cross.
Okay. And for cross-examination, we begin with MECG.
No questions, Judge.
Liberty?
Yes, Your Honor. This is Dean Cooper on behalf of Liberty. Ms. Boland, the staff agrees that securitizing the Winter Storm Uri and Asbury costs are expected to provide quantifiable net present value benefits to the customers, doesn't it?
Yes.
And that benefit is a result of the use of the securitization process, correct?
That is correct.
Okay. Now, you have a fair amount of experience at the commission, but let me ask you this. Do you view yourself as a tax authority?
I have worked tax issues before on other rate cases. So yes, I would consider myself somewhat of a tax authority.
Somewhat of a tax
Expert,
authority?
yes, somewhat, yes.
How about normalization? Do you consider yourself an expert on normalization?
I have performed those the calculations for determining normalized income tax in the past, yes.
Now, in reading your testimony as to ADIT, it appears that ADIT in this context is a function of the amount to be recovered through the securitization. Is that correct?
If I remember right, the net present value of the ADIT for Asbury is to be considered an offset to the securitized balance.
Well, and what I'm getting at is that in your testimony, you identify and you say that the company has, because of the amount it seeks to securitize, its ADIT is one number that's larger than the number you identify for ADIT associated with the staff's securitization number for Asbury.
That is correct due to our differences on the asset retirement obligation.
Right. And while we're on that, real quick, your counsel yesterday, let's see, an opening statement said that you had seen additional information in the company's surrebuttal in support of those asset retirement obligations, correct?
That is correct. I have reviewed the surrebuttal testimony of Drew Landell, and there was some independent analysis done on the ARO for the CCR.
And I think your counsel said, and I may be paraphrasing, but essentially said you're getting closer to being comfortable with Liberty's estimates. Is that correct?
That is correct. I'm not at the exact same amount, but there is a number in Mr. Landell's testimony on page 23 of 49 of DWL1 of $16,995,561 that we believe is probably appropriate to include.
Okay.
And that would be total company number.
Not a jurisdictional
Correct.
piece. Okay. So let's circle back to AIDIT for a minute. And would you agree that AIDIT is essentially about tax timing differences?
Yes, it is.
And when we say that, what does that mean to you?
That the company will be paying a different amount of taxes than what we would determine for rate-making purposes.
And so at the beginning of that process, the difference in those two things, assuming that customers have paid more than the company pays in taxes, that additional amount, and this is going to be a lawyer trying to say this, which is dangerous, but that becomes the AIDIT, correct?
Yes, it does.
But the assumption is that those taxes will eventually be paid, correct?
The assumption is that by the end of the life, the book depreciation life and the tax depreciation life, there will be no difference.
And in the interim, those amounts we've identified as the AIDIT are used to reduce rate base, correct?
That is correct.
And so a real simple example, if we had $1,000 in rate base and $100 in AIDIT, we would subtract the $100 from the 1,000, and the 900 essentially would be what we would use to calculate the return that would become a part of the annual revenue requirement, correct?
On the return of the revenue requirement, yes.
So ultimately, the rate implications of AIDIT come from this rate base impact. AIDIT does not have a dollar for dollar impact on annual revenue requirement, correct? It has an indirect impact on
It does
annual.
have an indirect impact, yes.
Now, were you in the hearing room yesterday when Mr. Stokes asked Ms. Emery to make modifications to her NPV AIDIT calculations?
Yes, I was.
Okay. And specifically, he asked her to change one of the cells from 2.47 to 6.77, correct?
And I think he also asked her to do it to 4%, if I remember correctly.
Now, did you use the rate of 2.47 in your NPV AIDIT calculation?
No, I used 4.
And why did you use 4?
That is the discount rate for securitization that we are proposing right
Yeah,
now.
so
That
that's-
staff is proposing, yes.
Okay, so that's the difference between the 2.47 and the 4 is that the 2.47 is what the company has identified as the bond securitization yield, correct?
Correct.
And the 4% you used is what staff has identified as the bond securitization yield.
That is correct.
Okay. Now, you said earlier that you were familiar with tax normalization rules, correct?
I am somewhat familiar with them, yes.
Now, for lack of a better way of saying it, violating normalization rules is a big deal, isn't it?
Yes, it is.
And I think in other contexts, we've talked about the fact that a violation of normalization rules can sort of eliminate a company's ability to utilize accelerated depreciation and some other things on a going forward basis, correct?
That is possible, yes.
And if that results, that's a detriment to customers, correct?
Possibly could be, yes.
As we walk through these issues, would you agree that we're at least sort of walking towards that issue of whether we have normalization violation or not?
I don't know that we are anywhere near the normalization violation on this.
I'm not asking whether you think there's a violation itself, but it's at least a question that needs to be asked as a part of the process. Wouldn't you agree with it?
I don't know that it is an issue in this case.
Well, let me ask you this. We have the difference, obviously, with the discount, or with the bond securitization yields that are being used by the company and the staff. And we don't know today what that'll ultimately be, correct?
That is correct.
And that plays a part in both the company's calculation and the staff's calculation, correct?
That is true.
And we already talked about the fact that there are differences that result from the amount that the company seeks to securitize versus what staff recommends be securitized, correct?
That is correct.
And we don't know the answer to what that's going to be today either.
That is true.
Okay. So even to the best of our ability, we can't come up with the right number for ADIT sitting here today, can we?
That's correct. We have to know all the factors that go into the Asbury securitized balance before we can determine that.
Given that situation, would a tracker help to ensure that we don't overshoot nor undershoot this number, nor accidentally walk ourselves into a normalization situation?
I don't know that it would help or hurt either one.
There certainly would not be any harm to a tracker.
There probably would not be as much harm, no, for a tracker.
And ultimately, don't you think that it would help us get the number right in the long term?
It is possible.
Now, real quickly, these issues are grouped a lot of times between ADIT and excess ADIT. As to excess ADIT was a separate issue than what we just discussed, isn't it? How would you describe excess ADIT as an issue in this case?
I believe company and staff are the same on the excess ADIT.
That's where I was going with that. There is no dispute between the company and the staff.
Correct.
Any substantial dispute between the company and staff on the excess ADIT amount, correct?
That is correct. There is a difference between staff and company have the same position, and OPC has a different position on it.
That's all the questions I have, Your Honor.
All right, then, public counsel. All right. Do we have any questions from the commissioners on the line? All right, I do have some questions. On page 3 of your rebuttal testimony, you state that Liberty filed a request for an AAO in case number EU-2022-0274 to seek recovery of the amount excluded from Liberty's FAC. One of the additions Liberty included in its requests are carrying costs at its weighted average cost of capital. What's been the Commission's past practice with regards to applying carrying costs for an AAO?
I have seen it allowed on some items. Mainly, in my experience, it's more items that are related to capital, such as repair of plant or replacement of plant.
And what rates would be applied in those situations?
I've seen a various amount of rates.
Is there a standard?
I've seen
for-
AFUDC, I've seen long-term, short-term. I don't know that there's really a standard.
Okay, that was gonna be my next question.
Yeah.
How did staff calculate the net book value for Asbury?
That should be addressed more to Amanda.
That was, and I did ask that of
Yes.
Amanda, never mind. And carrying costs for the AAO, originally it was gonna be short-term debt or long-term debt. Did staff decide to go on long-term debt on that?
Yes, we did.
Okay. Do you know the specific amount that the long-term debt carrying costs will amount to?
If I remember right, it's 4.65. Again, Amanda would probably be the more correct witness to answer that.
Okay. And would those carrying costs be consistent with the carrying cost used in Davis's rebuttal schedule?
Yes, they would.
Okay. Your counsel in his opening addressed a theory that moving the threshold of the amount to be recovered in securitization could preserve the 95.5 sharing mechanism for fuel costs. Can you elaborate on that?
Could you repeat your question?
Sure. Your counsel in his opening addressed a theory that moving the threshold of the amount to be recovered in securitization could preserve the 95.5 sharing mechanism for fuel costs. Can you elaborate on that?
Person who would be better to answer that is Brad Fortson.
Okay. We'll ask that of Brad. Charlotte Emery in her rebuttal states that securitizing estimated balances before they're incurred does not create risk for customers. Does staff agree with that statement?
I don't know that it creates a risk, but I don't know that it's proper to include amounts that are estimated in the securitized balance. There is always the chance that these items should be trued up later, but I just think it is more proper to include amounts that are are very well known and not estimated.
And what would be the reason for that?
It's just proper rate making. You look at what are the actual amounts.
Okay. Then please explain staff's position on the following disallowances for Asbury. First, the AAO regulatory liability.
Excuse me, could you repeat that again?
Sure. What's staff's position on the disallowance for Asbury of AAO regulatory liability?
That would probably be a better question for Amanda McMillan.
Okay. Same question for ADIT?
What is our position on ADIT?
Yes.
We have an amount of roughly 17 million for an offset. We believe that is what we have ADIT of 22 million, then you do a net present value and it comes to 17 million roughly.
Okay. Same for decommissioning?
Decommissioning, we had a value of, with the decommissioning and the AROs, we had a total amount of 23,445,264. Oh, I'm sorry, we had an amount of $8,399,713. But if we would include the amount listed in Drew Landell's testimony, our amount would go to $23,445,264.
Okay. And that last adjustment was about the AROs?
The AROs and the decommissioning cost and an environmental regulatory asset.
Okay. That's all the questions I have then. Any recross based on those questions from the bench? All right, any redirect then?
Yes, Your Honor. Kurt Stokes on behalf of staff. Let's start with the questions you remember you were asked about a tracker for the ADIT amounts. Do you have an understanding of what exactly Liberty thinks should be tracked in regards to an ADIT?
I believe they are wanting to track the payments they will make to the IRS.
Now, speaking of payments to the IRS, what is your understanding of what Liberty pays based on securitization?
Liberty will pay the taxes once the charges are charged to the ratepayers, and Liberty receives those securitized charges.
Okay. Now, they don't pay money on the actual, like when they sell the bonds and they get that large infusion of cash, they don't pay on that cash initially, right?
That is correct.
Okay. Now, elsewhere in your testimony, you talked about a reconciliation mechanism. Do you recall that?
Yes.
To the extent that your, staff would not be opposed to a tracker, would it be better to have ADIT accounted for in that same overall reconciliation mechanism than just an individual tracker?
I don't know that we can do that per the statute. I think the items that can be tracked are the energy transition cost, and I don't believe ADIT is listed in there.
Okay, so it would have to be its own.
Yes.
Yeah. Now, speaking of ADIT, what does ADIT represent at a very fundamentally? What is it?
It refers to when a company, in the beginning of the life of an asset, they incur, for this example, they get a higher tax rate because their tax depreciation rate is higher than what we use for rate-making purposes. So that is a deferred tax, and the company gets the benefit of the cash, so it is reflected as a rate-based deduction in rate base. Over time, that amount should turn around, and the customer should get the benefit while the company is paying has a lower tax deduction, is paying higher taxes than what we would reflect in rates.
Okay, so as long as the ADIT balance is positive, that is money that ratepayers have paid to the company, correct?
It is the difference in the tax deductions.
And the company possesses that ADIT balance.
That is correct.
And absent securitization, how would the company treat that ADIT balance over time?
Over time, it would eventually, for like one item, it would eventually be zero.
And what brings it to zero? What transactions bring it to zero?
As the differences are corrected over time and the customers receive the benefit.
Got it. So the benefit is early on in the life of the asset, customers are overpaying actual taxes, and late in the life of the asset, they're underpaying actual taxes?
That is correct.
Okay. So when you talk about today, there's an ADIT balance. What is the tax benefit of that balance?
The customer should be receiving that tax benefit.
The full amount?
The full amount, yes.
Okay. If I had an obligation to credit you $36 million over the next 13 years, would you accept payment of $5 million today?
No, I would not.
Why not?
I don't think that would be appropriate net present value.
Yeah, and when you say not an appropriate net present value, how do you calculate net present value?
You calculate it based on a rate and over so many years.
Okay. Do you multiply the annual balance by that annual rate, or do you use a different calculation?
I would use the yearly amounts I would receive in the rate.
And then do you take those yearly amounts and multiply them by a percentage, or do you use the NPV calculation?
I would use my NPV calculation.
And would it be appropriate to take that yearly amount, multiply it by a discount rate, and then use the NPV calculation again using the NPV rate?
No, it would not.
How did Charlotte Emery calculate NPV?
She looked at it as the actual rate base value
Okay.
and did the MPV on that.
Well, first, she took the yearly amount of the rate base and multiplied it by 2.47%, correct?
She used the revenue requirement value of rate base.
And so using the revenue, yeah, and then from that, she again used the NPV discount.
That is correct.
And is that what you mean when you say she discounted it twice?
That is what I'm alluding to, yes.
And did your calculation use a discount calculation once?
It only discounted the amount once. That is correct.
Okay. I think you had already talked about the relationship between ADIT and the AROs. So if the commission were to agree with Liberty on the AROs, your ADIT would be significantly higher than 17 million, correct?
That is correct.
Assuming the ADIT balance is 36 million, what should the net present value of that ADIT be?
I believe in my testimony I said 32 million. $30,831,327.
Okay. Let's move on to carrying cost rates. Are you familiar with the Commission's treatment of the Joplin tornado AAO for Liberty?
The carrying costs were applied to the capital expenditures, and they used the AFUDC rate. I am familiar with that.
Okay. So what is AFUDC?
Is accumulated funds used during construction. It is usually calculated by first utilizing the short-term debt of the company, and then once all the short-term debt amount is used, then it moves to a weighted average cost of capital calculation.
Now, a lot of the expenditures in the wake of the Joplin tornado, what kind of expenditures were those?
A lot of them, there were some O&M expenditures, but a lot of them were capital expenditures to repair or to replace a plant that was damaged during the tornado.
And your recommendation is AFUDC proper to apply to capital expenditures or
In that case, it was.
Mm-hmm. Now, similar to AFUDC, when you're talking about capital expenditures, including that rate base, that's your understanding of what the commission did at the 2019.
Yes, they included the unamortized balance of the Joplin tornado in rate base.
Mm-hmm. Now, here, what are the expenditures we're talking about for Winter Storm Uri?
These are fuel and purchase power cost.
Are there any capital costs associated?
I do not believe there's fuel and purchase power cost and some legal cost that the company has included.
Okay. Is your recommendation for long-term debt based on the fact that it's fuel and purchase power and not capital expenditures?
Yes, it is.
Okay. No further questions.
All right. Then, Ms. Mullen, you can step down. And that actually takes care of the witnesses that were identified for today, but it does indicate for time allows, we can go on to some more. And so we'll go with, I believe Brad Fortson would be next.
Your Honor?
Yes.
If it's okay with the commission and the parties have already consulted with Liberty on this, I'd like to call Sarah Lange out of order to avoid a potential scheduling conflict later this afternoon.
That'll be fine.
Judge, this is Nathan Williams for Public Counsel. Since staff's brought up availability of witnesses, I'd like to inform the commission that Lena Mantle has a conflict for tomorrow morning,
Okay.
just to make everyone aware.
She's on the, if time allows, for tomorrow, so.
I'm not anticipating it to be a problem, but you never know.
Okay. If you please raise your right hand, you solemnly swear or affirm the testimony you're about to give in this matter is the truth, the whole truth, and nothing but the truth.
I do.
Thank you. You may inquire.
Thank you, Your Honor. Kurt Stokes for staff. Good morning, Ms. Lange. Can you please state your full name for the record?
Sarah Lincleither Lange, Lange.
And in what capacity are you employed by the staff?
I am an economist in the Tariff and Rate Design Group.
Have you prepared in these proceedings certain rebuttal testimony marked as Exhibit 108?
I have.
Do you have any corrections to make to that document?
Not that I'm aware of at this time.
If I were to ask you the same questions of those documents, would your answers be the same?
Substantially, yes.
And are those answers true and correct to the best of your knowledge and belief?
Yes.
Your Honor, I offer Exhibit 108 into the record.
108 has been offered. Any objections to its receipt? Hearing none, it will be received. For cross-examination, then, for Ms. Lange, we begin with MECG.
Just a few questions, Judge. Your Honor, can I ask? I don't have with me exhibit numbers assigned to MECG. Can you remind me what that block might be?
I definitely can. MECGs begin with 300.
Thank you, Judge. May I approach the bench and the witness?
You may.
Ms. Lange, in your rebuttal testimony, you mentioned that I guess you addressed the testimony of Ms. Emery and Ms. Hall, and note that the classes listed in their tables are no longer accurate. Is that correct?
Among other things, yes.
And you were involved in Empire's last rate case that just completed in April.
Was there a question?
Were you a witness or otherwise involved in Empire's last rate case that completed in April?
Yes.
And after the completion of that rate case, were you involved in reviewing the rates that would be implemented, I guess, and the new names of the rate classes?
I'm sorry, there were a couple parts there. Could you help me out?
So you were involved in after the case and the commission's order were issued, you were involved in looking at the new rate classes names and the new rates that would be applied to each rate class, correct?
I was involved in review of the compliance tariff. I was not the only witness involved, and I did not handle all aspects of that.
Okay. I handed you, I guess, what I'd asked to be marked as MECG Exhibit 300. Can you tell me, have you seen this document before?
I have not.
You've not seen it in an Excel format?
I am not familiar with this document that you have handed me.
Okay. This document that I've handed you, does it contain the rate classes under the old Empire tariffs?
I see labeled current class revenues, and I see certain class designations provided there. Above it, I see reconfigured classes, and I see class designations listed there. This doesn't include the split out of the large general service class by primary and secondary that occurred in the rate schedules, and I have no knowledge of these other numbers provided on this page or these other columns.
The other numbers listed, just the headlines are stipulation revenues. Is that correct?
I see a heading of stipulation revenues. I am not familiar with the quantities listed under that column.
And there's another heading that says revenue increase, correct? Around the middle of the page.
There is a column labeled revenue increase. I'll note that this appears to make a distinction between the pre-MIA and non-pre-MIA. And I assuming that this document is mathematically accurate, I don't know how MIA is handled within this document.
The total listed under revenue increase is $35,515,913. Do you see that?
I see where you have read that number.
And that matches up with the revenue increase that was ordered in the recent Empire rate case, correct?
I don't recall. I'm
Okay.
not familiar with this document.
That's all the questions I have.
Are we gonna offer 300?
Sure, I'd offer Exhibit 300 into the record.
I object for lack of foundation.
Any other response?
Well, this witness has testified that she's not familiar with it, so there's no foundation I can lay.
Okay,
I should add, this is Nathan Williams who made the objection.
I understand. I'll sustain the objection. It will not be received. Okay, then, for Liberty.
Thank you, Your Honor. Ms. Lange, in your rebuttal testimony, you talk about excess revenues and do a calculation, correct?
It's probably more accurate to say I provide a summary of a calculation derived from the rate case, but yes, in general.
And you could call those excess base rate revenues, correct?
I'm sorry, could you say that again?
Well, I guess the distinction I'm trying to make, would you agree that, and I think you say it even in here, that these are revenues separate and apart from the FAC?
Yes, I'd agree with that distinction.
And what you've purported to provide us is a number of what you view to be excess base rate revenues representing the revenue from sales made during the Winter Storm Uri period, correct?
That's not entirely accurate. I believe early February there were some revenue adjustments in the opposite direction. This is simply the weather normalization for these classes from the prior rate, from the recently concluded rate case. This is the value associated with that from staff's revenue run. So I think there were some, if you will, under earnings, to use that term in a completely non-accounting and non-rate of return sense, earlier in the month that offset the over earnings, if you will, during the Uri period. And again, I'm not using that in a rate of return sense of earnings.
In the end, does what you represent in your testimony here, does it cover, what period does it cover then, given what you just told us?
I believe, because of the way Empire's billing months are arranged, To be completely confident on this, I'd need to look at Empire's billing cycles. I believe that it encompasses a period starting for some customers in early to mid-January through late February, possibly into early March. Empire's billing cycles span, I believe they're on a 28-day spread from the earliest to the latest. So since we have to review this information on a secular basis to coincide with the billing cycles, there's really no way to isolate that period with the data that is available from the company. And that was an incredibly long explanation, so I hope I answered your question
Yeah,
there.
so let's circle back around. So at the longest period, it could be from late January to early March of 2021. Is that what you told me?
It is a series of customers' 26 to 32-day bills. Some of those customers starting, I believe, in early January, although I'm not entirely sure without reference to external material on that, to the latest ones being in late February, early March. Again, I would need to access Empire's billing data to confirm those dates, but essentially this is set up so that the largest number of customers, it is capturing that period of the Storm Uri event, correct?
And it does not purport to assess whether for the calendar year 2021, Empire/Liberty would have been, what its revenues would have looked like in regard to normal weather for the entire calendar year of 2021, correct?
That is not included in these figures, correct?
So did you do that calculation for the entire year of 2021?
That calculation was done in the rate case for purposes of this case to coincide with the Uri event. I isolated, or I caused others more familiar with the calculation to isolate those billing cycles for those billing months which are most closely related with the Uri event. And I apologize, this is definitely not my forte.
Who produced the number in the rate case for the calendar year 2021?
If you'll continue to indulge me with a very complex answer to a very simple question. So I believe in that case for these classes, staff witness Kim Cox would have applied adjustments generated by staff witnesses Michael Stallman and Ari Pudel. However, that adjustment in the rate case was applied in conjunction with, I believe, the customer growth adjustment and possibly also a days normalization to account for billing cycle differences over the course of a year that would deviate from a total of 365. And so what this presents is that weather normalization adjustment isolated from those growth and other adjustments that were applied in that single step in the rate case, is my understanding.
But getting around, I guess, to my simple question, that would have been produced by Kim Cox?
Not really.
Well, but let's back up.
Sure.
If I were looking for it in someone's testimony, whose testimony would it be in?
So this exact calculation would not be in anyone's testimony because the weather and those other adjustments I mentioned were applied in a single step. What Ms. Cox prepared at my request for purposes of this testimony isolated the weather adjustment, so I could simply subtract pre-weather normalization determinants from post-weather normalization determinants, as is what is shown in my work paper.
So let's back around then. Given all that, would it be accurate to say you do not know what a similar calculation would look like if we were to examine the entire 2021 calendar year?
Not without looking at staff's work papers in the rate case.
Yeah. You provide, I think, what is some, is this proposed tariff language? How would you describe Schedule SLKL-R2?
I know we got particular about the terms we used. I want to say that we would call this specimen tariff language, but I'll agree with proposed as well.
Okay. And hopefully this is not a, well, we'll see where it goes. Would you agree with me that the securitization statute requires the commission to make its initial allocation or to identify the allocations to the classes as a part of its securitization order?
I know the language on that is, I'm sorry, if you have a copy of the statute handy, that could save some time. I neglected to print one out this morning. I think I quoted in my testimony, but I'm looking for it.
Yeah, I think you do too. Let's start there. Could you give me just a second? How about on page 11 of your rebuttal? Line 13.
Yes. And I apologize. I think your question was, does the statute state that the commission is to order how it will be allocated? Was that your question?
That was the question.
Yes, it does.
And it also says that it shall remain in effect until the electrical corporation completes a general rate case or a general rate proceeding, correct?
Yes, there's additional language there, but yes.
So, and this is really just an explanation that I'm looking for from you. On page 5 of your specimen tariff language, you've got some factors that are going to be as approved in most recent general rate case or in a proceeding conducted for that purpose. Does that have any relation to our allocation question?
Yes, so I would recommend, and I think it's in staff's position statement, that we would recommend that for purposes of complying with this provision of the statute, the commission could simply include in its order something to the effect of that it is allocated to the retail classes on the basis of each class's loss-adjusted energy sales. And what these are on page 5, where it VAF, subscript prime, et cetera, what that is referring to would be, for this case, we would simply adopt those from the FAC and include those. And that would, by knowing the number of sales at each level, by knowing the loss adjustment factor to apply, you then have any dollar value you may need to ascertain. I do not know that it would be inconsistent with the statute to simply state the sentence, that it is on the basis of loss-adjusted energy sales.
So I guess the language that's bothering me a little bit is the voltage adjustment factors approved in most recent general rate case or in a proceeding conducted for that purpose. I guess first off, we wouldn't have any change until the first general rate case, correct? Or
Any change
go ahead.
from blank?
Let me back up. The allocations would not change until the first general rate case, right?
I apologize that I seemingly have very obnoxious answers to your very simple questions. This is, of course, the complexity that makes regulation so interesting. That depends. One of my criticisms of the company's recommended mechanism is that you are attempting to keep revenues within classes, even though determinants within those classes may change. And so you could apply an energy allocation in that manner where you are tying that revenue requirement back to, you are tying the securitized utility tariff charge revenue requirement back to an individual class based on an initial allocation, and then we just ignore if, say, a bunch of general service customers become residential customers, or vice versa, as has happened in recent Empire history, or we would ignore if a customer who is a large customer who was served at primary voltage moves to the transmission voltage. You could do it that way. I would be very cautious about doing it that way. And to circle back to your actual question, which is where all this was headed, you would find these loss factors now based on the most recent rate case. I don't think staff anticipates changing those loss factors until we get to a future rate case, but I think we recognize that a party could file a complaint and say that the FAC or other loss factors are inaccurate and they've done a loss study and that it turns out that those factors need to change.
But ultimately, regardless of how we think it's going to work out, we have to be convinced that what we're doing is consistent with that statutory provision that we read, correct?
Correct.
And so it must be approached in a way that the allocations, once established in the securitization order, we have to be able to say they do not change until the first rate case, correct?
No, that's where I think you need to be careful how you read that sentence. So the initial allocation shall remain in effect. What does it mean by allocation? What I think it means by allocation, or what I think it can be reasonably read by allocation, is the voltage adjustment energy the voltage adjusted energy sales. So that is the allocation. The allocation is not we take the energy sales for residential and apply a secondary loss factor. Do you see what I'm saying? I think that is a fair reading of that language.
Yeah. So the way you've approached it, you certainly would argue that it doesn't ignore that provision in the statute, correct?
I believe I technically would not argue that. My attorney would. But
yeah, that's right.
I think that what I've done here is consistent with the statute, or I wouldn't have done it.
Yeah. Just a moment, Your Honor. Just a kind of a backup to our initial discussion about the excess revenue adjustment. In the way you've done it, we talked about you've isolated a period, correct?
Correct.
But if we were in a rate case, we wouldn't isolate periods like that. I think that was implicit in your answer, correct? We would be working with a test year, or a test year updated, some sort of 12-month period. Is that correct?
For a rate case, my experience is that for expense and revenue items, you use a 12-month period, correct?
Yep. That's all the questions I have here.
All right. Over to public counsel.
Nathan Williams, no questions, thank you.
All right, we'll move up to questions from the bench. Any questions from the commissioners on the line? I do have some questions. Charlotte Emery's rebuttal testimony suggested that the parties would collaborate and agree on a form of tariff prior to the financing order being issued. Do you know what timeline and process Liberty is proposing, and can the parties agree on those terms?
So, continuing my trend of long answers to simple questions, it depends. With the energy allocator approach, I think that based on my past experience with Empire and OPC, I think we can do a pretty short turnaround on that. We work collaboratively on tariffs on a pretty regular basis. If a class-specific approach is adopted, that will become significantly more cumbersome, and a new design will need to be developed. And particularly if a demand charge approach is adopted, that is not something the parties have contemplated in the prepared tariffs, and not something we are able to lift, if you will, from MEAs and RAMs and, you know, kind of existing tariff provisions. So that will require some more work and potential more dispute as what those KW determinants might be, if that would be facilities demand, billing demand, some demand determinant that we may not have readily available. And I'll note we do not have normalized demand determinants that are as reliable as our KWH determinants, particularly for certain classes. So that process could be very lengthy.
And am I correct in understanding then that the tariff does not need to be approved as part of the financing order?
I will defer to counsel on that. I believe, based on an early reading of the statute, it's been a while since I've studied it on this regard, that ideally we would know in this order what that tariff is supposed to look like, but that a final tariff would not be promulgated until after the bonds have been issued.
Okay. And if the parties cannot get together and work this all out, how would the commission resolve the question of what the tariff looks like?
Again, I think it depends on that earlier. Well, I don't know. That's the real answer. I don't know.
Okay. Now, the next question is about issue 8 regarding the allocation of tariff charges among the retail customers. Please outline for the commission the difference between Staff and Liberty's tariff allocations and what's the significance of the difference.
If you're wanting a dollar value, I don't know that I can rapidly outline that.
I'm not looking so much for a dollar value as I am just
Sure.
an idea of what the differences are.
Empire has had some different percentages thrown out, but my understanding is that they want to look at how total revenue was allocated in the last rate case, allocate that to the recomprised classes, figure out something to do about electrical vehicles, and then lock that down until the next rate case occurs. Staff's approach would be to say, come up with total system sales, loss adjusted, and that is the rate that gets applied to every KWH sold at the rate at which it is sold. True-ups would be on a total company basis. Reconciliations would be on a total company basis. Under the Empire approach, I believe that they are indicating you would need to do class-specific true-ups and reconciliations.
Okay. And what impact does these differences have on the large industrial classes? I guess
I think it depends. There are customers within the class, I think, who would prefer one approach over the other, particularly if a demand charge is introduced. I think that there are some customers, I don't think you could, I'm sorry, could you ask it again?
Okay. Well, what I'm trying to get at is the idea that does one process opposed to the other have a disproportionate impact on the larger rate classes or the larger industrials?
I think it matters if you're looking at a customer level or a class level. There will be, anytime you do different allocation factors, there are winners and losers, if you will. My understanding of the factors, well, I don't know if Empire's is loss adjusted. In general, the Empire approach would initially recover less from, for example, the large power classes. But if there were a change in that class, if a customer were to drop off or were to drop down to a smaller class, then that change would need to be made up within the class. So it is hard to say as a whole if those customers would be better off or worse off under one proposal or the other.
Okay. And under the statute, are the parties required to decide on a mechanism for allocating the tariff charge among the retail customers as part of the process before the issuance of the financing order?
Well, I believe that needs to be included in the tariff, or in the report and order.
Okay.
Again, that could be as simple as saying, on the basis of energy adjusted sales, I don't, or loss adjusted sales, I don't believe you need to include orders and the numbers in the order.
Okay. And what are the substantive differences between staff's tariff sheet and that proposed by Liberty?
Without taking a cheap shot, Liberties includes terms that don't exist under Missouri regulatory law. Well, I guess that was taking a cheap shot, but I didn't intend it in a ill-spirited way. The Liberty order appears to be lifted from another jurisdiction and is generally
Were you talking about the Liberty tariff now?
yes, I'm sorry. The Liberty tariff appended to the Liberty draft order includes terms that are not used in Missouri. It refers to a threshold rate and threshold usage that appear to be integral to implementing their true-up mechanism that are not defined in the tariff. When we inquired about it, Empire said, yep, they don't apply here. But it doesn't appear a workaround was included for that. It refers to distribution rates when in fact it's sales for all retail service. The biggest issue is that it focuses on truing up within classes, and that becomes very cumbersome. And frankly, I'm not sure how to do it, and I don't know that Empire is sure how to do it. I think Mr. Stokes inquired of Ms. Emery yesterday, and I believe that was her response.
Okay.
Staff's is very similar in operation to MIA's ResRam's existing mechanisms under Missouri tariffs.
Now, given that the statute has a non-bypassable provision, does staff's proposed tariff sheet contemplate how changes to customer classes would be addressed in the future?
When you say customer classes, staff's tariff avoids that issue entirely.
And how do you do that?
Because we recover on the basis of energy sales. So it matters what voltage you're served at, so we know how to adjust your rate to fit what your voltage at transmission level would be, or what your usage at transmission voltage would be, I should say. But the customer's class doesn't matter in the way that it matters in the Empire draft.
Okay. I believe that's all the questions I have. And back for recross based on questions for the bench, beginning with MECG.
Thank you. Ms. Lange, the judge was asking about the impact on industrial classes compared to your proposal versus the company's proposal. And you said you weren't sure which would have a bigger impact, correct?
Correct.
And the reason you weren't sure is because you were suggesting that things may change in the future in regard to the number of customers in that class?
I don't believe I isolated it to that concern. I also include the recent addition to the potential outcomes of a demand charge.
Comparing the company's proposal as filed indirect, they were seeking to recover it as a kilowatt hour charge allocated to class, correct?
Subject to true up within the class, correct?
And yours is proposing to simply collect it from every customer according to a kilowatt hour charge,
Adjusted for the voltage at which that customer is served.
essentially treating it like the FAC, correct?
Correct.
Under those two scenarios, holding everything else equal, industrial customers would pay more under your proposal than under the company's proposal.
I would have to do some math at what the applicable, I guess, average customer voltage is and what the difference is between energy sales and the company's allocation.
The company's allocation in Emery's testimony for large power, do you have Ms. Emery's testimony available to you?
I don't have a copy with me up here.
I have a electronic copy open. Judge, may I approach the witness and
You may.
show her that? Is that Ms. Emery's testimony?
You are representing it to be Ms. Emery's testimony. I have
Feel
no
free to-
reason to dispute your
Okay.
representation that you've opened a document out of EFIS.
Okay. And for large power, what is the allocation proposed by the company there?
They seek a target revenue of $2,121,560.
And to get your rate allocation, using these figures here, you would take the total revenue target divided by the total class, not total class usage, the total usage, correct?
Their usage here does not appear to be adjusted for losses, and staff's revenue target, my understanding, is significantly lower than that sought by Empire. So I would not do either of those things.
All things equal, without the voltage adjustment, the way to calculate a kilowatt hour rate would be to divide the revenue target by the total usage, correct?
I
And that's how you
Could
get
you
your kilowatt hour figure that you then propose to adjust by voltage. Is that right?
No. You project voltage you project sales at each level, and then you add that together, and then you divide.
So it's your testimony that under the company's proposed allocation of 15.83%, you can't say that your method would allocate a larger percent than 15.83% to large power.
That, think you need to clarify between percents and dollar values. Staff is recommending a smaller dollar value be recovered.
Staff is recommending a smaller dollar value. If we were to have the commission award staff's proposed dollar value and the company were to prevail on getting its recovery method, it would get 15.83% of that value to allocate to the large power class, correct?
Yeah.
And under your method, it would get a larger percentage of that staff's value, correct?
I would expect it to be larger. I don't think I've done that math.
That's all I have. Thank you.
And for Liberty,
No questions, Your Honor.
Public Counsel.
Nathan Williams, no questions, thank you.
All right, and redirect.
Kurt Stokes for staff. Let's start with the weather revenue adjustment. You were asked that, like in a rate case, you would look at like the full year, right?
Staff would look at the full year, correct?
But this isn't the full rate case.
Correct.
This is a securitization case.
Correct.
And we're looking at just costs incurred during Winter Storm Uri.
Yes.
We're not looking at, Liberty doesn't look at Winter Storm Uri in the context of a full test year.
I have not been involved in that portion of the case. It's my understanding that they are attempting to isolate to the period as closely as possible.
Okay. And when you say a company has earned more than normal based on weather, you said you looked at the full month of February based on billing cycle issues?
Well, it's essentially portions of the full portions of, there's no easy way to say this. To get the portion of the month of February in which Uri occurred, we had to look at customer bill cycles, some of which began, I believe, in early January, and some of which concluded, I believe, in late February or early March. But it would be what we would refer to as the billing months of January and February.
Good. So assume that a customer's billing period begins in mid-January. It would end 26 to 32 days later. At some point during Uri.
Making assumptions about Empire's billing practices and cycle dates and that sort of thing. Yes, that is what we assumed for purposes of the normalization in the rate case.
Okay, but then for like a customer whose billing cycle began like right before, during, or during Uri, then that's the one that would be continued out through late February or early March, right?
Correct.
Okay. Okay, let's go to, you were asked about, concerns with Liberty's cost allocation proposals. You had mentioned, an incomplete, not matching up with all of the current classes, but you said there were among others. What are some other concerns you have?
Their mechanism appears to rely on what is called a threshold rate and threshold usage. I think what that is trying to accomplish is to deal with some of the rate switching potential, but it's not clear and it certainly isn't defined, and I've been unable to work out a way that it makes sense to me. There's a rate switching issue. There's how their true-up is actually implemented. Essentially with their proposal, it appears that there would be risk, especially for large customers, of rates potentially doubling. If you have a few customers, if you have a small percentage of the number of customers who make up a large percentage of that class's sales, be it KW or KWH, and those customers either cease to operate or move to another class, the customers within that class have to make up that shortfall. And particularly in the environment we've been in with, industrial load declination, if you had one or two large customers that went out of business, you would see that large customer rate potentially double. That is my main concern, is how the rate switching and customer attrition operate under their true-up mechanism.
You mentioned customer attrition. Would there also be if things change in the next 13 years, you could actually see customer additions to certain rate classes?
Well, sure. I think we've seen steady residential and SGS customer growth, which under Empire's proposal would cause those rate classes to have decreasing charges per customer until you get to a rate case when you would rebase everything. Or rebase is the wrong word in this context, but refresh and reallocate under their proposal.
And with the consequences of customer attrition and growth and other things, would that risk, without your proposal, your Liberty's proposal, do you think it would risk under recovery of amounts needed to service these bonds?
I think the greatest extent I can answer that question would be to say that the larger a rate changes, the higher the likelihood that you will have issues with obtaining full payment of that rate.
And is it your understanding that investors are very sensitive to the true-up mechanism?
That is my understanding from representations from staff's consultants.
And is the true-up mechanism here related to your cost allocation proposal? Meaning using voltage-adjusted energy sales to calculate?
I don't know how you would have an allocation and a true-up that are not designed to work in tandem. I think you have to be cognizant of each when implementing either.
So they're necessarily related?
Yes.
Earlier you had mentioned that staff's approach kind of avoids the cost allocation, but staff's proposal of having costs allocated based on energy sales, that's just your way of addressing how you allocate costs, correct?
Yes, and if I may have misspoke, my intention was to say it avoids the obligation or the apparent, it avoids the need for the commission to include finite percentages or dollar values in its order. It does not avoid allocating the costs, it necessarily is allocating the costs.
Thank you. Now, you had read the statute earlier, right? I think it was on, as you quoted at page 11. The statute uses the word allocated among retail customer classes, not the phrase allocated between retail customer classes. Is that correct?
That appears to be the language.
Okay. No further questions.
All right, then, Ms. Lang, you can step down. Thank you very much. Then the next witness will be Mr. Fortson.
That is correct.
Good morning. Solemnly swear or affirm testimony you're about to give in this matter is the truth, the whole truth, nothing but the truth.
I do.
Thank you. You may inquire.
Thank you, Judge. This is Kurt Stokes again for staff. Mr. Fortson, can you please state your full name for the record?
Brad J. Fortson.
And in what capacity are you employed by the staff of the commission?
I'm a regulatory compliance manager for the Energy Resources Department.
Have you reviewed in these proceedings rebuttal testimony marked as Exhibit 104?
Yes.
And you're familiar with everything in that rebuttal testimony, correct?
I am.
Do you have any corrections to make?
I do not.
Exhibit? If I were to ask you the questions in those documents, would your answers be the same?
They would.
And the answers to those questions are true and correct to the best of your knowledge and belief?
Yes.
And would you adopt Exhibit 104 as your own testimony in this case?
I would.
I offer Exhibit 104 into evidence.
104 has been offered. Any objections to its receipt? Hearing none, it will be received.
I tender the witness for cross.
Okay. And for cross, we begin with MECG.
No questions, Judge.
Public counsel.
Nathan Williams, no questions.
Liberty.
Dean Cooper for Liberty. Yes, Your Honor. Mr. Fortson, from pages 4, line 12 to page 5, line 15 of, I guess, what is now your testimony, there's a description of the staff's analysis and review of Liberty's deferred fuel and purchase power cost, isn't there?
What pages were those again? I'm sorry.
Page 4, and we'll start on line 12. There's a question, please describe the work conducted by staff regarding this application within the scope of the Energy Resources Department. Do you see that?
Sure, I do.
Okay. And then I think that continues on over into page 5 and really through line 15. after there's a description of individual staff witnesses that worked on part of the review. Do you see that?
I do.
And would you agree with me that as a result of that review, there were no disallowances proposed by staff based upon imprudence?
I wouldn't completely agree with that.
Well, let's back up. The disallowance identified in the testimony is essentially 5%, correct?
Yes.
Okay. And maybe this gets to what you're talking about. You also have a disallowance, I suppose, that's based upon the testimony of Jordan Hull, correct?
We do, yes.
Okay. Now, as a part of staff's review, did it examine power purchase agreements where Liberty is making sales to other entities?
It's my understanding we reviewed all of the Storm Uri costs, the fuel and purchase power and off-system sales.
Your Honor, may I approach the witness?
You may.
Do you have before you a document that I just handed you?
I do have a document in front of me that you just handed me.
What does that appear to be?
It appears to be a data request.
And let me caution you before we go further. At some point, we may need to go in camera, but we'll try to stay out of that for the time being. It's a data request from staff to the company,
It is.
and there's an answer provided by the company.
There's a response, yes.
And attached to that response is a power purchase agreement. Is that correct?
That is what it appears to be.
And the data request was submitted by Lisa Wildhaber. I've probably butchered that pronunciation. I apologize, but you can correct me on that. But that's a staff person that requested this this power purchase agreement.
Lisa Wilhaber, yes.
Wilhaber. And Lisa Wilhaber is mentioned specifically in your testimony as one of the staff persons doing the review in this case, correct?
Correct.
And this is the sort of agreement that you would have expected staff to have reviewed as a part of its work in this case?
Sure, yes.
Your Honor, could we go in camera at this point?
All right. Hold on one second.
That's all the questions I have at this point in time.
All right, let's deal with 22 Mr. Williams, do you still object?
As before, I object to it being admitted as hearsay. I do not object to it being admitted for the purposes of a document of the nature of which staff would review and presumably may have done so in this.
Okay. I'll go ahead and admit the exhibit. If there's any issues about the content of it, you can address it in briefs. Okay, then for the cross, then we move over to public counsel. Oh, I'm sorry, you passed already. So we're back up to questions from the bench. Any questions from the commissioners on the commissioners on the line? All right, I do have one question. And this is a question that...
Not at this time, Judge. Thank you.
Thank you. Your counsel in his opening addressed a theory that moving the threshold of the amount to be recovered in securitization could preserve the 95-5 sharing mechanism for fuel costs. Can you elaborate on that?
Yeah, so what I think Mr. Stokes was getting at was, I think more so if we don't preserve the 95-5 within securitization, that could, I think we run a much greater risk of the parties being unable to agree what thresholds or amounts to the amount of cost to remain in the FAC as opposed to what is carved out and securitized. You could potentially see a situation where if the company is allowed to securitize 100% as opposed to 95%, an instance where the company wants a larger amount, they're more incentivized for a larger amount of cost to be securitized, whereas other parties then would very likely argue we should leave more costs in the FAC. So I think it's more preserving the 95-5 within securitization likely reduces the risk of arguments as to what should be left in the FAC as opposed to carved out for securitization.
But ultimately, it'd be up to the commission to make that decision.
Ultimately, yes, for sure.
Okay. That's all the questions I have then. Any recross based on that question?
Yes, Your Honor. Can you turn?
Recross first.
Oh, sorry.
Thank you, Judge. Nathan Williams for Public Counsel. Didn't that event actually occur?
Yes, to some extent it did.
Thank you.
Okay. Mr. Cooper.
Thank you, Judge. Maybe real briefly. You would agree that there's no specific reference to the 95-5 sharing in the securitization statute, correct?
Similar to the FAC statute, it and the securitization statute neither explicitly speak to a sharing mechanism.
Yeah. Well, the FAC may speak to a sharing mechanism, but not a certain dollar or not a certain percentage, right?
It makes, to my knowledge, it makes no reference to specifically to a sharing mechanism.
Would you agree that the 95-5 ratio that we're talking about here in regard to Liberty is a function of its fuel adjustment clause?
There's a 95-5 sharing mechanism in the FAC, yes.
And would you agree with me that the commission indicated when that was adopted that there was sufficient incentive to operate at optimal efficiency and still provide Liberty with an opportunity to earn a fair return on its investment?
Without knowing exactly where you got that from, I have seen language very similar to that from previous commission orders.
Okay. So that sort of description would not surprise you then, right?
No, it would not.
Hold on just a second. Now, as we talked about before, other than this 5% disallowance and then perhaps the disallowance proposed by Staff Witness Hall, staff didn't allege any imprudence associated with these fuel and purchase power costs, did it?
So my thoughts on that are that this testimony doesn't explicitly state imprudence for the 95.5, but I would consider it alleged imprudence on the company's part of proposing 100% of these fuel costs in this case.
So nothing imprudent about the way they purchased their fuel and purchase power, correct?
Other than what the other, Mr. Hull's disallowance, I would say it's more of an imprudent in action of this proposal as opposed to action of its fuel costs.
So imprudence of its ask?
Imprudent asking for 100% as opposed to 95%.
Okay. Now, if we start with the concept that the 95.5 is supposed to provide Liberty sufficient incentive to operate at optimal efficiency, and we have no imprudence alleged as to its fuel and purchase power activities, does the incentive have any purpose at all in this situation?
I think for future cases, and if and when another Storm Uri-like event occurs, there's that incentive is very important.
But as you indicated already, ultimately, that's a decision for the commission.
That is a decision for the commission.
Right? So it's not as if by incentivizing the company one way or the other, the commission has backed itself into a hole. They maintain the authority to make that decision, correct?
Preserving the 95.5 within securitization cases for fuel costs, I think allows for the same sort of incentive as the 95.5 is intended in the FAC.
But in this case, it had no impact, correct?
Well, one thing I think that needs to be noted is that in February 2021, if I remember right, and you know better than I, the securitization wasn't law at the time. So we wouldn't have, I assume, wouldn't have been anticipated to securitize or know that we were, the company was going to have an option to securitize. So I don't know that I can give an answer on the 95.5 and securitization as it applies to Storm Uri, because at the time, those are different variables that weren't in place all at the same time.
Yeah. But ultimately, you'd agree that the costs that we're talking about in this case, seeking to securitize, are extraordinary costs, correct?
I would agree that the parties deem these extraordinary costs, yes.
Yeah. That's all the questions I have here.
All right. Now redirect.
Finally, thank you. Sorry, I jumped the gun earlier. Mr. Forson, you were asked about a document earlier. Is that document, are you able to authenticate that document that it is what it purports to be?
I'm just taking it at face value as to what it states it is.
You're not a party to that document. You're not
No.
signatory.
No,
You weren't involved in the negotiations of it,
no,
and you don't know what the provisions mean.
not specifically.
You don't know if that contract is still in effect.
I do not.
You don't know if there are subsequent amendments to that contract.
I do not.
You don't know if that contract has been, arbitrated.
I do not.
You don't know if that contract has been litigated.
I do not.
You don't know if there's a court or arbitrator that's interpreted in a way that you're not aware of.
No, I do not.
Okay. Let's talk then about the 95.5 sharing mechanism mentioned in testimony. You were asked whether there was any impact from the 95.5 sharing mechanism on Liberty's decisions in this case, correct?
Correct.
Can you say for sure if that Liberty's actions would have been the same if there were no 95.5 sharing mechanism?
Can I ask a clarifying or to clarify? Well, can you rephrase or repeat that?
I guess stated another way, isn't the fact that there was no impact, doesn't that mean that the 95.5 sharing mechanism was doing exactly what it was designed to do?
Well, I would say, if I'm understanding your question correctly, that, I mean, as I previously mentioned, securitization wasn't law at the time. So the 95.5 incentive that was in place for the FAC for fuel costs should have been the incentive for the company to, as Mr. Cooper previously stated, something to the effect of, to be a sufficient incentive to operate optimally efficient.
Now, do you remember Liberty's FAC filing in case ER-2022-0332?
I'm familiar with it.
In that case, Liberty requested their FAC charge just be reset to 0, and anything above that, they were asking to be deemed extraordinary, like an extraordinary cost.
Correct, that's how I recall it.
Okay, so it was really kind of, what Liberty did is they started at a proposed fuel adjustment rate and then backed into what costs they would deem extraordinary.
Sure, there was no definite number that determined what extraordinary was.
Were there other proposals to set the cutoff for what qualified as an extraordinary cost?
As I recall, Office of Public Counsel suggested another option that would have allowed for a higher rate, a higher FAC rate, lower amount of extraordinary costs.
Okay, so OPC's proposal, customers would have immediately seen a higher FAC rate.
Correct.
Do you recall the magnitude of how much higher?
Ms. Manna would, but I'm wanting to say it may have been $8. It was equivalent to the highest amount that the commission has ordered in an FAC or an AFAR filing for Empire.
Okay. You said it was around potentially $8.
Subject to check and to a question for Ms. Mantle.
Do you recall, was staff concerned with the level of that increase and that under that proposal?
We were. Both options were reasonable. So ultimately, staff was, honestly, I mean, just given the circumstances, I don't want to say we were indifferent. It was, what can we come to an agreement on? What can the company, Office of Public Counsel agree on that's reasonable? Both were reasonable. There was a concern of a, spike in FAC costs immediately.
So there was a lot to consider.
There was a lot to consider.
Now, are you familiar with Liberty's AAO relating to the URI costs?
Not as much, but somewhat.
Are you familiar with their specific request in that case for commission language in an AA order stating that they would be entitled to recovery of that as they would be under the FAC?
I do recall that.
And that case is still pending?
My understanding, yes.
And Liberty's request under that AAO for that specific language is still pending before the commission, correct?
If I understand correctly, yes.
So their alternative to securitization in AAO, they're saying do treat it like an FAC, that they are entitled to recovery.
That would be my understanding.
Okay. Can you turn to page 3 of the rebuttal testimony where the fuel adjustment clause, I'm sorry, yes, where the fuel adjustment clause rule is quoted? It's lines one through 4.
Top of page 3, yes.
Okay. Now, did you hear Ms. Emery testify yesterday that she believed that that rule prohibited extraordinary costs from being passed through?
I did.
But the rule actually says, and I quote, extraordinary costs not to be passed through, if any, due to such costs being an insured loss or subject to reduction due to litigation or for any other reason. That's the full language of the rule, correct?
It is.
Now, based on that, do you read that as just a blanket prohibition of all exclusion of extraordinary costs, or does there have to be some reason to exclude an extraordinary cost?
Yeah, I don't read this as a blanket. Yeah, there are definitely parameters around deeming such costs as extraordinary.
Now, if a utility were permitted to recover 100% of fuel costs instead of 95%, would that be a reason not to exclude extraordinary costs from the FAC?
If the company is allowed to recover 100% in securitization, you would very likely see an instance where they would want a higher amount of extraordinary costs or deem all fuel costs or whatever cost at hand would be extraordinary to carve out for securitization.
But somebody opposing a utility request could say, I don't want this extraordinary cost excluded because I want the 95.5 sharing mechanism.
Correct.
No further questions.
All right. Then, Mr. Fortson, you can step down.
Thank you.
And we're due for a lunch break. We'll break for lunch now and come back at 1 o'clock. Okay. And we are now ready for our next witness, Jordan Hall. If you please raise your right hand. You solemnly swear or affirm the testimony you're about to give in this matter is the truth, the whole truth, and nothing but the truth.
I do.
Thank you. You may inquire.
Thank you, Your Honor. Kurt Stokes on behalf of staff. Mr. Hull, can you please state your full name for the record?
My name is Jordan Timothy Hull.
And in what capacity are you employed by staff of the Commission?
I am the Associate Engineer for the Energy Resources Department.
And have you prepared in these proceedings certain rebuttal testimony marked as Exhibit 105 in public, confidential, and highly confidential?
Yes.
And do you have any corrections to make to those documents?
No.
If I were to ask you questions in the same questions in those documents, would your answers be the same?
Yes.
And your answers would be true and correct to the best of your knowledge and belief?
Yes.
Your Honor, I offer Exhibit 105 in its public, confidential, and highly confidential versions into the record.
All right, 105 and its confidential, highly confidential and public versions has been offered. Any objection to its receipt? Hearing none, it will be received. For cross-examination, we begin with MECG.
No question, Your Honor.
Public counsel.
Nathan Williams, no questions, thank you.
All right, for Liberty.
Dean Cooper. Your Honor, Dean Cooper for Liberty. Mr. Hall, in looking at your proposed disallowance related to River 1011, it does not mention any adjustment to go from total company to Missouri jurisdictional. Did you make such an adjustment?
I don't think I understand your question.
Well, I take it that in your calculation, and let me start with this, you first off considered, well, how many megawatts did you consider to be in play with River 1011?
15.
And River 1011 provides service to Missouri, Kansas, Oklahoma, Arkansas. Would you agree?
I'm not sure.
Okay. So you don't have any idea what a Missouri jurisdictional adjustment would be?
No. I know the capacity that is on Evergy's or Empire's capacity balance sheet. Which is what Empire would be using from, could use from that unit.
And Empire, let's say you're not aware whether Empire serves in Kansas or Oklahoma or Arkansas, correct?
Whether Empire does? Mm-hmm. I think they reach into other states, yes.
Okay. So there's
Liberty Empire does.
So they would have they would utilize that generation to serve all 4 states, correct?
I think they could.
So the whole concept of a total company cost for Liberty Empire versus a Missouri jurisdictional cost is something that you're just not familiar with.
I don't think it would be appropriate in this situation.
Okay. Were you in the hearing room this morning when Mr. Fortson was on the witness stand?
I was.
Did you hear us discuss what's been marked or what has been admitted into evidence as Exhibit 22HC?
I don't have it in front of me, no.
Okay. Did you hear us discuss it, though?
Yes.
Do you want it in front of you?
I would.
May I approach, Your Honor?
You may.
Is that a document that you had seen before I just handed it to you?
No, this is the first time seeing it because you just handed it to me.
So it would be safe to assume that you did not take anything into account in your disallowance related to SPP revenues that might be due to other entities than Empire. Is that correct?
That'd be correct.
So you assumed all 15 megawatt, the SPP revenues associated with all 15 megawatts would be Empire's to keep.
Yes.
Now, just hypothetically, if, this is probably just simple math, if Empire was only due SPP revenues for 1/3 of those 15 megawatts, your disallowance would be as simple as being 1/3 of what is reflected in your testimony, correct?
Your Honor, I would object as speculation and irrelevant and lack of foundation.
I'll overrule the objection. You can answer.
Can you say the question again?
Sure. So in your calculation, you essentially came up with a number that you assert represents SPP revenues associated with 15 megawatts. If hypothetically Empire were only to receive 5 of those 15 megawatts, your disallowance would be 1/3 of what's reflected in your testimony, correct?
Yes, that would be the math.
That's all the questions I have for right now, Your Honor.
All right, we'll come up for questions from the bench. Any questions from the commissioners on the line? All right, I do have some questions. This first couple questions relate to the idea that Liberty might have planned more effectively for Winter Storm Uri. After the retirement of Asbury, which had a capacity of approximately 190 megawatts, what dispatchable capacity did Liberty still have?
I wouldn't be able to say that off the top of my head without looking at a capacity balance sheet to see if you subtract that from the total, what it would be.
Okay. Do you know if a capacity balance sheet was in the
It's in the
testimony?
IRP.
It's in the IRP?
Yeah.
Okay. Was Riverton 11 capable, permitted, and approved by the Kansas Department of Health and Environment to operate under emergency conditions with fuel oil during the February 21, 2021 event?
Yes, they got a waiver to operate, and the first stipulation to where they could operate was met in their permit,
Okay.
where gas supply was interrupted.
And when were they given that waiver?
That waiver was on the 15th.
Of February?
Yes.
Okay. So before that, they could not have used it?
I think they still could have because it was already met that their gas was interrupted.
Okay. So there were,
There's nothing saying that they had to have gotten the waiver. I think it was more of a verification that,
okay.
that's my understanding, based on reading the permit.
Does the permit differentiate between operating with fuel oil and testing with fuel oil?
What do you mean by that? Can you clarify your question?
I'll try. Is there anything in the permit that says even if they can't use the fuel oil, they could test with the fuel oil to make sure they would work?
Yes, the Black Start test requirements.
Okay, would that apply to Riverton 11 at that point?
According to their permit.
Judge, I think when we get off into
Should we
some
go
of these
camera?
identifications
Oh, I'm sorry,
of Black Start.
that's HC.
Can we go in camera?
Yeah, let's go in camera for a moment. In Mr. Robinette's rebuttal for public counsel, he indicated that your proposed disallowance for Riverton 11 was very conservative, and he proposed a further disallowance. What's staff's opinion on that proposed disallowance that Mr. Robinette made?
I think, which, I don't know if we can be in camera for this or not.
Well, we can go back into in-camera again if we need to.
Okay.
Let's go back. We're back in regular session, and I have no further questions for the witness, so we'll move to recross based on questions from the bench. And beginning with MECG.
No questions, Your Honor.
Public counsel.
Thank you, Judge. Mr. Hall, do you recall testifying that Liberty had filled other tanks with diesel at other locations
Does
and
this
at
need to be
Riverton?
HC again, or in camera?
I don't believe so. That's all I was going to say about it.
Okay, that's fine.
If the company's not concerned, I'm not concerned.
Me neither. I just wanted to make sure. I didn't want to step on
Okay,
toes.
I understand.
Do you recall that?
Yes.
Did Liberty generate electricity from any of those other locations?
I don't know the answer to that.
And, well, let me clarify it a little bit. And I don't think it's going to change your answer, but those locations where Liberty had filled its fuel oil tanks, aside from Riverton, did it run any of those units that used that fuel during Storm Uri?
I don't know the answer to that.
Thank you.
All right, for Liberty.
Yes, Your Honor. Let's start with this fuel oil question. It is true that there are limitations on, even under your reading of the permit, on when Riverton 10 and Riverton 11 can run on fuel oil, correct?
Yes.
And so, do you remember whether Mr. Mashimba testified as to why, or that because of that, that fuel oil would not be fully stocked at Riverton as opposed to other locations?
No, I do not.
Mr. Hall, if you get a little bit closer to the microphone, you tend to speak kind of softly.
Sorry.
Now, I apologize. Let me try to do one more thing before we go, or a couple more things before we go in camera, Your Honor. Mr. Hull, in reading your statement of experience, education, those sort of things, is it true you graduated from college in 2016?
Yes.
And is it true that from college you went to work for Missouri Department of Natural Resources?
It is.
And you worked there for a few years, and then you came to work for the commission, correct?
Correct.
And so, am I safe to assume that you've never worked for an electrical corporation or electric utility?
That is correct.
Would I be safe to assume that you've never been responsible for either tuning or starting a combustion turbine similar to the one at Riverton 11?
That's correct.
And so you would also not have any experience trying to start such a turbine in sub-zero temperatures, correct?
No.
Your Honor, could we go in camera for a minute?
All right, we'll go in camera at this. And we're back in regular session. And Liberty has indicated they had no further questions, so we'll move to redirect.
Thank you, Your Honor. Kurt Stokes for staff. Can you generally are you familiar with the Riverton facility, not just Riverton Unit 11?
Yeah, I'm generally.
How many units are there?
There are 3.
Okay, can you identify those?
Riverton 10, 11, and 12.
Okay. During Winter Storm Uri, which ones were and were not operable?
All of them were offline because of gas issues, pressure issues.
Was Riverton 10 offline for other reasons?
Because of bearing failure on the 8th.
And then Riverton 12, what, was it down?
Yes, due to gas pressure issues.
Okay. So now previous to Uri, was Riverton 10, or I'm sorry, Riverton 12 down for any reason?
I don't believe so.
Okay. Was Riverton 12 generating electricity before Winter Storm Uri?
Yes, I would assume so.
Okay.
I just looked at the outages once it happened. So.
Once it happened. Okay. Now, you just answered Mr. Cooper that you had never actually started a unit or tuned a unit correct?
That is correct.
But you have written air permits, right?
Yes, I have. That's what I did at Natural Resources, Missouri Department of Natural Resources.
Okay. How many years did you do that?
2.5, 3 years.
Okay. And is the Kansas Department of Health and Environment, is that the equivalent of Missouri's Department of Natural Resources?
That is my understanding.
And when I refer to Kansas Department of Health and Environment, I'm just KDHE.
Mm-hmm.
Is KDHE the same thing as SPP?
As SPP?
Mm-hmm.
No.
So they're two separate entities, right?
Correct.
SPP requires one designated Black Start unit, correct?
Correct.
You've read Liberty's air permit from KDHE, right?
Mm-hmm.
And you're familiar with it?
Yes.
It has Black Start testing allowances for Riverton 10 and 11, correct?
Yes, it does.
Is there anything in there about the unit having to be designated with KDHE?
I did not read anything about that in that permit.
Okay, so based on your reading of the permit, regardless of the designation with SPP, for KDHE purposes, would Liberty be allowed to engage in testing of any of its capable units?
That is what that section says.
Okay. Now, SPP has a requirement to designate one unit, correct?
Yes.
Do you think that, why do you think there's a requirement for one designation? Is that a minimum requirement or is that a maximum requirement?
I would think that would be a minimum requirement.
Right, because maybe just having one unit would not be great.
For reliability purposes, I think it would be better to have more than one, yes.
Yeah, and Liberty had more than one.
Correct. Well, they didn't have more than one designated, but they had more than one in their permit that they could have used.
And as you read that permit, they could have maintained testing for all of its Black Start capable units, regardless of what their designation was at the time with SPP.
Yes.
And Liberty did not do that.
According to the NERC standard, they had to test every 3 years, and the last time that I had, whenever I asked, they said the last time they tested it was 2016.
Yeah. Let's move on to the integrated resource plan filed by Liberty. You had referred to that earlier.
Yeah.
What does the IRP address with the commission?
It basically just said it was a dual fuel unit and that it can operate in winter and summer. And they have it designated as dual fuel for both peaks, both because Liberty is dual peaking.
Now, you also heard the testimony of Dr. Mashimba this morning when he stated that tuning of a unit is something that's done regularly, correct?
Yes, that was in his DR response.
And that you would, tuning was recommended when you have extreme changes in temperature, right?
Correct.
And what temperature was Riverton 11 tuned to?
70 degrees.
And as far as you can tell, was tuning of Riverton something that was done?
Objection, Your Honor. I think we're beyond the scope of cross and bench questions.
I'll overrule the objection.
So as far as you can tell, was Riverton 11 regularly tuned?
I wouldn't call 2016 regularly tuned.
No, I didn't say testing. I said tuned.
Tuned?
Yeah.
Oh, it wasn't tuned at temperatures for winter seasons.
Mm-hmm. It was tuned to 70 degrees, right?
Right.
And is tuning to 70 degrees consistent with a recommendation to tune to extreme weather changes?
I wouldn't call 70 degrees extreme weather, no.
Mm-hmm. And is Riverton 11, is that a peaking unit?
It is a peaking unit.
And can you tell me what peaking units are designed to do?
To be used whenever there's a peak in electrical use.
Is a peak in electrical use likely to happen at 70 degrees?
No.
No further questions, Your Honor.
All right. Then, Mr. Hall, you can step down. And the next witness would be Jay Lubert. Please raise your right hand. Do you solemnly swear or affirm testimony about to give in this matters the truth, the whole truth, and nothing but the truth?
Yes, I do.
Thank you. You may inquire.
Your Honor, may I approach the bench and the witness?
You may.
Sorry.
But we. Okay.
I'll wait.
I have no room to talk after this morning. Mr. Lubert, can you please state your full name for the record?
My name is Jay Lubert.
And in what capacity are you employed with the staff of the commission?
I am the manager of the Tariff and Rate Design Department.
Have you prepared in these proceedings rebuttal testimony marked as Exhibit 106?
Yes,
And do you have any corrections to make to that document?
I do not.
If I were to ask you the same questions in Exhibit 106, would your answers be the same?
They would be substantially similar, yes.
And are those answers true and correct to the best of your knowledge and belief?
Yes.
Your Honor, I offer Exhibit 106 into the record.
All right, 106 has been offered. Any objections to its receipt? Hearing none, it will be received. And for cross-examine, we begin with MECG. And you may approach.
Good afternoon, Mr. Lubert.
Good afternoon.
In your testimony, you support the mechanism proposed by witness Lengi for recovering securitized costs, correct?
I believe my testimony is supportive of the allocation of costs for Asbury.
Using the same mechanism as described in the testimony of witness Lengi?
Yes.
And under that mechanism, would you agree that industrial classes will pay more than under the company's proposal?
I don't know that I can say that confidently.
All things being equal, customers remaining the same, moving forward in each class, could you say that under the mechanism proposed by staff, industrial classes will pay more than the company's proposal?
I don't know.
Why don't you know that?
To be frank, I wasn't a part of the development of the class cost of service study and the last rate case.
In fact, staff didn't do a class cost of service in the last rate case, correct?
I don't know.
Okay. Now, I handed you a document, and I think I'm up to Exhibit 301. Can you take a look at that document? And that's the report and order from Empire's most recent rate case, correct?
It appears to be.
Can you turn to page 12? And I'm looking for number 20. I'm just going to refer you to it. Are you there?
Yes.
And that's in the commission's findings of fact in that order. And it says, the results of Empire's class cost of service study support a higher increase for residential customers since their current rates recover less than the cost of service. Did I read that correctly?
Mostly. It says it supports a higher rate increase.
Higher rate increase. With that correction, you agree that's what the report and order said?
I believe that is correct.
And if you would turn to page 10. Are you there?
I am.
On point 13, the commission notes that Empire prepared a class cost of service study. Is that correct?
That is what paragraph 13 says there.
And it doesn't say anything about staff preparing one, correct?
It goes on to say MECG did not prepare a CCOS study but modified Empire's CCOS study to produce its own results.
And
it does not mention
does not mention staff? Okay. So that seems to indicate staff did not file a class cost of service study in that rate case?
Again, I don't know.
Weren't you a witness who offered testimony in that rate case?
I was.
Okay. I'll admit I don't support the view, but would you agree that if the commission wants to issue an order shifting more costs to industrial customers, the commission can do that?
Could you repeat your question? I'm sorry.
If the commission wanted to, they could issue an order shifting more costs onto industrial customers. You'd agree they could do that?
In what context?
Your Honor, I would object only to the extent he's asking for like a legal conclusion and not like an expert opinion.
I guess I'm not asking for a legal conclusion. I'm just, in your understanding of how the commission issues orders and in your understanding and participating in cases, there are instances where the commission shifts rates and increases to different class, correct?
Correct.
Do you think it's staff's role to inform the commission what the impact of its recommendations are on the customer classes?
I would agree with that sentiment for the most part, yes.
You say for the most part, what part don't you agree with?
I don't. I guess there could be instances where the impact isn't known at a given time, and to the extent that it would be speculation, I don't know that it's always true that we should be providing information if that's the case.
And you didn't provide that information about the difference impacts on rate classes between staff's mechanism and the company's mechanism in this case?
I did not.
Okay. Did anyone from staff?
I don't know.
Mr. Lubert, what is your position with the commission?
I am the manager of the Tariff and Rate Design Department.
And in that role, do you supervise any employees?
I do.
Your Honor, may I approach again?
You may.
And just, Your Honor, for the court and for the council, I handed Mr. Lubert what I previously circulated as Exhibit 300 also. So I'm going to ask about that as well. I didn't bring additional copies than the ones I circulated earlier.
I believe this has a cover sheet that 301 did not, or
Yeah,
300 did not.
I did not hand you the 300. I'm just noting that the one that I handed you earlier when Ms. Lange was testifying, I'm going to reference because I handed Mr. Lubert a copy as well.
Okay.
Okay. Mr. Lubert, that top document I gave you is Exhibit 300. Were you in the room when Witness Lange was looking at it?
I was.
And I guess the transcript will show what it shows, but basically she denied knowing anything about that document. Do you agree with that?
I don't know what Ms. Lange knows or doesn't.
What did she, do you agree that she testified that she didn't know anything about that document?
I'm not sure.
Okay. Now take a look at exhibit, I guess I'll call it Exhibit 303. It's the one I handed you that's not an email. And it's very similar to Exhibit 300, correct?
I'm not completely certain what I'm looking at right now. So I've got a sheet here that says
That's 300.
X300, and then there's an email. So the other,
that
the
sheet.
last sheet?
Yes.
Okay.
And that looks very similar to Exhibit 300, correct? fact,
there are a lot of numbers here and a
if-
multitude of columns and rows, so I'm
in fact,
hesitant to
I'll
say
propose to you that they're identical except for a comment bubble.
Do you want me to verify that, or?
Do you see a comment bubble on there?
I do see a comment.
And that comment is attributed to Sarah Lange, correct?
That comment appears to.
Your Honor, I'm going to object to relevance and foundation and hearsay.
What is the relevance of this?
This is a document I asked Ms. Lange about earlier, and I'm asking, would it address your concern if I got to the chase and asked Mr. Lubert if he recognizes this document?
I'll sustain the objection.
Okay.
At this point. You can ask further questions.
Mr. Lubert, is this a document that you recognize?
I can't say that I do.
So you didn't have any hand in preparing or commenting on this document?
I don't believe so.
Okay. Can you look at the email document? And that email is from Counsel for Empire. Is that what that document shows?
Yes, it appears to be from Diana Carter.
Okay. And I guess, Your Honor, I'd have that marked as, I think it'd be 30.
300 was what we talked about with Ms. Lange. 301 was the report and order that you had.
302 then.
30, did you want?
Or I guess I'll call that other one 302 and this one 303.
303, okay.
And that email purports to contain a attachment or two of them, doesn't it?
If you give me a moment to read it.
It would be near the top.
It does appear to reference an attached work paper.
Okay. Is it staff's policy that we need a forensic evidence trail before a witness can know something it looks like they themselves had a hand in making?
Objection. I think he just asked about how to lay a foundation for a document under Missouri law.
I'll withdraw. I have no more questions, Your Honor.
All right, we've got some documents here now. Did you wish to offer any of them?
I'll offer the report and order. The others I will not offer.
Okay, so we're talking about the report and order in ER 2021-0312. Any objections to its receipt? Hearing none, it will be received. And the other two are not offered. Okay. And for further cross, then we'll go to public counsel.
Nathan Williams for Public Counsel, no questions, thank you.
For Liberty.
Tim Cooper for Liberty, no questions.
Okay. Do we have any questions from the commissioners on the online? I do have a couple of
No questions, Judge. Thank you.
Thank you. On page, in McMillan's rebuttal testimony, she stated that it was staff's position that the prudent costs incurred by Liberty for the early retirement of Asbury are just and reasonable and in the public interest. Why does staff believe that the early retirement of Asbury was prudent and reasonable?
I don't think that I can speak for the staff position whether that decision was just and reasonable.
Okay. Any recross based on those questions from the bench? Redirect.
Thank you, Your Honor. Kurt Stokes on behalf of the staff. Maybe just an aside, a point of clarification. I want to make sure I have the Exhibit 301 is the report and order from case number ending 0312. Is that right?
That's correct.
Okay. Mr. Lubert, can you turn, or can you get page, Exhibit 301 and turn to page 18?
That was a report and order, correct?
Yes.
Okay.
And the last paragraph, the second sentence, can you confirm that it says the commission is not addressing the validity of Empire's CCOS study because the CCOS study and MECG modified study presented in this case are not the primary driving factor driving the commission's decision?
Yes, that is what it states.
Okay. No further questions, Your Honor.
All right. And then Mr. Lubert, you can step down. And I believe that would be the last witness for today. Anything else we need to take up before we adjourn for the day?
This is Nathan Williams for Public Counsel. I don't know if you necessarily need to take it up today, but the other day you reserved ruling on, I believe it was Exhibit 21, which were the additional schedules to Ms. Emery's testimony.
Correct.
Public Counsel's had an opportunity to review those and believes they are what they purport to be, so I'm not making an objection to that exhibit.
Then 21 will be received into evidence.
And Judge, that has been sent to that email address you provided
Okay,
as a separate document.
very good, thank you.
I had 2 points, Your Honor. The first one was we have Mark Davis scheduled to appear Thursday remotely. And so just at some point in time, we'll need the WebEx contact call-in information for him
Yes.
to appear. And then we also have Ms. McMillan working on a calculation right now that the commission requested. I think our intent is to file that as Exhibit 116.
Okay,
So just file that directly in EFIS and copy the email address with the exhibits.
yes, and then bring it up when we get back on the record and we'll admit it at that time.
Okay.
Or consider admitting it.
Okay, thank you.
Okay.
Judge, this is Nathan Williams for Public Counsel. With regard to scheduling, I want to remind you that Ms. Mantle has a conflict tomorrow morning, at least part of the morning. So we may end up taking her in a different order than how she's listed, depending on how things play out.
That'll be fine. For tomorrow, we have Michael Mosindi to be the first witness for Liberty. And then we would have Robinette, Mantle, Riley, and Mark, and we can adjust those as we need to and
Thank you.
accommodating. Yes,
Judge,
Ms.
I
Carter.
might just give you the heads up on Mr. Mazandi. I just got a note from him that his flight has been delayed many times.
Okay.
He is now set to be able to fly into St. Louis by 9 tonight, but I will just give the heads up, I guess, that could happen again, and so we may need to reach out about a potential shifting for him as a witness.
Okay. I assume that we can just move into the public counsel witnesses then if we need to first, other than Ms. Mantle.
As far as I know.
Okay. All right, thank you.
Thank you.
Then we are adjourned until tomorrow morning.